Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
So, how would you like me to proceed here?
What are the charges? Again, all the ones that...
Well, right now you're not doing a very good job of representing yourself, because you don't even know what you're charged with. Let me tell you again.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Friday to you. Friday. That's a funny clip. That's a funny clip. Okay, I think I'm organized enough. Glasses on and right on time. Well, I went live at 9 o'clock, but it's like 9:03 before I show up on screen. So, the seats are not working very well. I was fighting with them this morning. They're going slow. Let's see if it's kicking in here. Yep, it's working. Okay, I fixed it. All right, congratulations, Ginger Snaps. There we go. Ginger Snaps. Congratulations. You're first in chat today, which means that your excitement and exuberance for the day has been made apparent for all to see. And clearly, you deserve some sort of punishment for that. We're going to send it to you to internet ownership the rest of the day, or at least until we go live again. You are responsible for everything IP-related worldwide. You're going to do great. So congratulations and thank you, and good riddance at the same time. Let's see. Maddie says, my new channel is called The Court of Public Opinion. There you go. Let's see. Greener's reporting what I was going to fill out. It sounds better coming from you, Greeners. My case has been found to be without merit, has been dismissed with prejudice. This is true. But even though dismissed with prejudice, there's no hard feelings, Greeners. I realized you went after the jugular on this one, and it was misguided. But all is forgiven. Welcome back. We missed you. That's all. And nothing more shall be said of this ever again. Greeners, thank you very much. That was a lot of fun. Who won the internet on CrowdStrike crash day? Which one was that? CrowdStrike crash? I don't know what that is. He went after the wrong people. Yeah. Let's see. Ginger Snaps won the internet. Yes. Happy Friday. Had a podcast last night. It was a lot of fun. Hopefully you joined or at least got to watch on the replay. That's a lot of fun. We've got, let's see, I think it's landlord tenant matters in some of these courts. We might have a new case that comes up today, possibly. Maybe. We're looking for a couple things to fall into place for that. So if not, we might have to go back and play catch up on another one. But let's see. Lizzie says, I was all excited for my massage with Sergi this morning. Got out of my flat, which was rare. Got to the place across town only to realize I'd booked it for November. Oh man. You're like, Sergi, do us a favor, you know? Let's see. CrowdStrike was like 50% of all businesses' computers went down because of anti-malware protection, went funky, lots of blue screens. Oh, okay. I remember that day. Who was that? I'm sure whoever on the internet remembers that day as well. The day that shall be remembered in infamy. Let's see. I want to search for the Dave Attenborough Beetle thing today at break. Do it, Carol. It is so good.
This all the apocalypse may be upon us.
Wendy says, "Love the intro music." I love that you love it. I believe this is one from the YouTube library, media library for creators, which for some reason they only give you access to after you've met the monetization threshold. But it's like free. It doesn't cost anything. YouTube owns the rights to it, and yeah, it's a good song. It's called Press Fuse. It's good. It's some good music. I like the build up. It's not too long. I mean, I like a good crescendo in a pump you up song. I mean, I've spent years filming college basketball, and we design the music literally in those things to control the crowd and hype them up and everything. And there's some great songs out there. I'm thinking, let's see, Wolf Mother has one, I think. Is that the right one? Wolf Mother? You'll know the song. Yeah, everyone knows the song and nobody remembers the name. I thought you wrote Press Fuse. I thought I did as well, but I didn't. All right. Kathy covered a new case that's starting. Is this the David Stearns one? Because we're hoping for David Stearns today. David Stearns out of Florida. Wild case. It's another murder trial. It doesn't involve children, thankfully this time. That would be good. But it's, allegedly, David Stearns shot and killed his girlfriend. Is under suspicion. The cops are watching him, and he goes back and burns the body and scatters the remains while the cops are watching. So that would be an interesting one. I think he's going to take a plea. I mean, always a plea. But that's allegedly what happened, and so we'll see if that develops today. It should be. I think it would be opening statements today if it becomes there. If he takes a plea or just pleads guilty, because that'd be interesting. Let's see. Let me do a quick check on that one. Florida v. David Stearns. Yeah, it's not. I don't think it's ready yet. We'll see if it develops. All right. What is it about Florida? Jennifer, it's not that Florida just has crazier criminals and more of them. It's that Florida is a sunshine state, which means that they are open to sharing information about courts and legal processes. As a matter of fact, most records are just by default, it's presumed that you should have access to them. I love that. We love that. For those that like to watch court, it makes a lot of things accessible. And it lets us be able to find out about things before they go to trial. There are other states that are much harder to find documents on. Like the process of getting documents is either really slow, so you could request them and within 90 days they'll respond to you, and they cost money. Whole court cases can happen in that time. So unless the news followed the story, breaking news when it happened, there was a press release about the crime when it happened, there's a lot of tension that way. It sort of just slides under the radar, and people just go through little trials in empty courtrooms that we would love to sit in on and listen on and watch and find intriguing. But Florida, open records, that's why it helps so much. Legally Blonde. Finally, a wholesome case. No kids. Seriously, I need one with no kids. Just let's take a little break for a while. Leave the kids alone. According to my sister, who spends half a year in Florida, Florida has crazy criminals. I'm not saying they don't. I mean, the Florida man has become a meme, right? Chuck E. Cheese cases in Florida, yes, with the old judge. Oh, we have to sing. I was forgetting birthdays. Thank you, Red Pen, for not letting me do that. Let's go to the birthday song. Kathy Trout, Curly Q NPR, Donald, Sarah, Sheena, and Stacy. Who was it that we sang to yesterday that had the birthday today? Was that on this list? I think we've got it. Hey, criminals, leave those kids alone. Do, do, do. Good song. Another brick in the wall. I think that's all. I think we've got them all. You guys ready to sing? Or dance? Because you have to do one or the other. All right, everyone stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. La 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 la. There we go. I'm swinging my feet because I'm just feeling the music today. I'll probably kick a cable. Happy birthday to you. Happy birthday to you. Happy birthday to Kathy Trout, Curly Q, NPR, Donald, Sarah, Sheena, and Stacy. Happy birthday to you. Go shorty, it's your birthday. Happy birthday, Kathy Trout, Curly Q, NPR, Donald, Sarah, Sheena, and Stacy. I realize there are many wonderful days, but today is your day. There are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully we can return some of that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, McDonald's, Tammy Dunlap's House, Andy's Grill, Bob Evans, and Cracker Barrel. Yes, Waffle House, I left you out. Honor the tradition, and I'll put you back on the list. All this attention and free advertising, Waffle House, could be yours. Could be yours for the price of a free waffle. Yes, I'm not trying to cancel you. I'm not that guy, right? I'm not the cancel guy. But one waffle, seriously, one waffle. Look how many hungry people there are in chat. Odds are the birthday person isn't even in your area. Anyway. All right. Get ready for your daily air drum lesson. This is the final. Once you've completed this one perfectly, you will be officially a drummer. Waffle House will the only thing you can get on the house. Okay, it's time for the air drum solo at the end. Everyone grab your air drum stick, sit down to your air drum set, and let's finish this song off in style as Greeners flirts with the line. Beautiful, beautiful. Happy birthday. Welcome back, Greeners. That's how we know it's you. That's how we know it's you. Let's see. Good morning. Good morning. We really want to watch court, but here's the issue. I'm trying to find court that is not landlord tenant. For this reason, landlord tenant is always about somebody who doesn't have enough money, who is in the process of being kicked out of their house. Always. How sad and depressing is that? It's not something I find funny. And occasionally there are some inspiring stories, but on the whole, it's a little rough. I'm not sure if Michael McNally is doing landlord tenants on Friday or not, but we'll keep an eye on him. He's not live yet. That's Judge Dad. We'll keep an eye on Judge Dad. Obviously, some of the courts a little further west do some different things on the Fridays as well. So let's see who we have. I think Warren County is doing something. Common Pleas Court. Let me listen in just briefly.
How do I reconcile that with your coming in here saying, "Oh yes, I've admitted my guilt. I was wrong." How do I reconcile that with what your words are? This is after you've already pled guilty, and then you send a letter to me, which I read, by the way, and indicate that you admitted your guilt, but you kind of said in your letter that you didn't do anything. How do I justify that?
Is he wearing a sheriff badge?
I was angry, Judge. I lost everything. I was just angry. There was a video. I did walk away. I did get punched, spit in my face, slapped, hit, my property destroyed. That did happen. It doesn't justify nothing. But it did happen. I was angry, Judge. And I can tell you, I'm sorry.
I'm going to go further because you couldn't stop there. During the process of preparing this report, that they had some follow-up questions for you, and your response was, "Fuck probation. I'm not speaking to them." Then you called back and you answered the questions. This is for pretrial. Asked if you'd be willing to comply with all orders of the court if granted community control. Your response was, I will not do community control unless it is non-reporting. I have given enough for this M1. I want to rebuild my life. I'm going to resolve the M1 Hamilton County, then go to North Dakota. Right?
North Dakota might not want him.
Didn't write ever anything about F probation or whatever that was. I don't know what that's about. I mean, again,
that was a phone call, apparently.
I'm in no position to sit here and say, hey, it's just a misdemeanor. Judge, all I'm saying is, I'm not going to say anything because I obviously get myself in more trouble here. Look, I'm sorry. I'll leave it at that.
The lawyer's got his head down.
I was angry.
All right, the court has considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Mr. Burleson, I'm not going to supervise you. I'm not going to waste everybody's time. You clearly don't want help. I don't think that putting you at this point in time in an inpatient treatment facility that you're going to like that or that you're going to want that. So I'm just going to order you to serve 136 days in the Warren County Jail. You'll get credit for the 76 days you've already served, and then you will be terminated. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. That's it. Anything else?
No, Your Honor.
All right, that's all.
Gives him another basically 70 days. This is one we can't rewind on, unfortunately. Yeah, don't when probation calls, don't say blank probation to them. Miss McGuire. It's got that similar sound. Wow. So, wow. It's an interesting little development. Those chains sounded like reindeer. Let's see. Seeing if they're done, if they're going to do something else. I like that belt badge, that little, the fob from the belt. Is it a keychain badge or a pocket clip badge? That's just cool. One day when I'm a cop, which will never happen, I'm going to get me one of those. Maybe I'll have to get a fake one. Not like one that says police or something, but let's see. Let's see if we have any other. Middleton's still doing tenant stuff. This morning I was watching one of my favorite YouTubers, Luke McFadden, who does crabbing on the Chesapeake. He catches blue crabs. He's a crabber. Catches blue crabs and sells them at a roadside stand. And he loves boats, and so he bought the cheapest boat he could find on Amazon. That's a bolt together boat, and he gave it a review. It basically sunk on him. And then he modified it to be like a tiny little super dangerous skiff, and he gave it 10 out of 10, which was funny because he practically drowned and sunk that one too. Let's see. We could do catch up on Spence. Spence has some audio issues that need to be fixed. Let's see what's happening up here.
Would you like to proceed?
Your Honor, it's my understanding in talking with defense counsel that we are going to waive the preliminary exam. Just one moment while I review my notes. There was a plea deal on the table. if he would plead guilty to count 1, we would dismiss count 2 and the HAB offer. I believe that defense counsel is proceeding with that. I defer to Mr. Williams, though.
Well, first, actually, Mr. Williams, we still don't have an appearance from you in the file, so I'm not sure we can proceed at this point.
Amazing, Your Honor. One was sent out. I have a copy of it right now, and I will certainly get another copy over to you. I'm not really sure why that is the case, but it surprises me. So how would you wish to do it? You want me to fax it over to you right now?
I'm sure we have a fax, but I'm not sure we have a fax in this day and age.
What's a fax?
Why don't we?
Email?
Why don't you email it to Ms. Lewis?
All right.
D. Lewis at.
We're not going to give away Miss Lewis's email. At. At tobedeleted.com.
A plea next week. We'll set it for, if it's all right with Ms. Lewis, the knower of all and doer of most, we can set it for a plea on Thursday morning so we don't have to renotice. First, Ms. Lewis, is that workable? Any other suggestions?
That's fine, Your Honor.
Okay. Mr. Baird, does that work for you?
Yes, Your Honor. Just to be clear, is this an in-person plea then? Or is it by Zoom?
Yeah, and it's the policy of this court that we do pleas and sentencings in person.
Yes, Your Honor. Fine.
Okay. Mr. Williams, does that work for you?
This is what I have on next Thursday, Your Honor. I have a matter in the 54A court.
There is a poll in
Judge
the bedroom.
Simmons. Let me see what time of day that is.
I like to think it's a handrail.
Let me see. Just 1 second, please.
I'm just wondering, is this also the lawyer's office? He just operates out of his home, and there's just the bedroom with the pole right there.
At 9:30, in front of Judge Simmons, I have a felony prelim. But I could certainly do it afterwards or before that time or whatever you wish. But that's got to be in person in 54A.
Well, certainly. And you would have had a preliminary exam in this matter scheduled for 9 a.m. If your client had chosen to proceed with a prelim. So, trying to think through what we have the rest of that day. Ms. Lewis, your thoughts on calendaring? Okay, we can do the plea. Oh, I just saw the message. Thank you. Okay, so we can do the plea on October 3rd.
I think we're going to go to Judge Wolf.
That's a Friday. Yes, that's good with me.
Okay, and we will set that for, I'm inclined to go with 9 a.m., but let me ask the knower of all and doer of most.
9 a.m., Your Honor, is fine.
9 a.m., okay. So we will set this plea for 9 a.m., October 3rd.
Got two pictures to show you as well. It takes a bit of time to get these lined up.
Anything further, Mr. Williams?
Nope.
No, it's a pleasure always to be in front of you.
Thank you. So all bond conditions continue, and we will see you all back in this matter at 9 a.m., October 3rd. Mr. Letts, best of luck to you, sir. Thank you.
Thank you. Thank you. And thank you, Mr. Baird.
Thank you, sir.
That poll. I've always heard the attorney has to pass the bar, not the poll, but he has the poll. Wanted to show you a couple pictures. It takes a little bit for me to get these lined up, so sorry about the delay. It's not an easy process, but here's one. This is the Space Coast. I think that's the NASA vehicle, the launch tower, all that thing. That one up close. That's where all the magic happens as far as launching things into space. And thank you very much for, I think this was Kaylee. Kaylee took these pictures. Glassy River, rocket launch pads, and NASA's vehicle assembly building. Right there. Looks beautiful. Looks like something you'd want to water ski on. Which would ruin it for everybody else because it's no longer glassy. You'd have waves then. But let's go see if we can find Judge Wolf from yesterday and go back to the beginning and do a quick one-day sov sit with Judge Wolf. That would be awesome. Where are you at, Judge Wolf? Scrolling. There he is. There, boom. Pro se.
Defendant pleads not guilty to each and every offense embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during...
Because it's the intro. They take a break. They go to lunch. They come back from lunch. The jury's now got their instructions, and we're going to pick up right here. I realize we covered some of this yesterday, but we're going to do it again. For those that missed it, we'll stick with this one today. How about that? Here's a sov sit.
All right, anything before we bring the jury in?
Judge, I wanted to address one thing briefly before the jury came in. When I read the indictment, I, of course, read it as would be anticipated for a bifurcated trial. So the defendant is charged with driving on revoked third offense, and I just wanted to be clear for the record that that was what he was pleading to.
It is clear for the record that the defendant is, in fact, charged with third offense, but because it is a bifurcated trial, I'm sure Mr. Spratt has probably explained that to you, Mr. Vaughn, but a bifurcated trial means under our rules, the jury cannot hear that you have been twice before convicted of driving on a revoked license. They only know that's your charge. So we will have the trial, and because on the third or the second count, but because you have been convicted of a driving on a revoked license, you have pled guilty to that, then it was a third offense. Is there going to be any contest about that being a third offense?
Nope. So he had two charges. He just pled guilty to driving on
because under the rules, what would happen is
license.
that we would have to have a bifurcated section that for the jury to determine whether or not you had two prior convictions.
He's talking to his elbow counsel. We haven't seen him yet, but you're going to see elbow counsel. This is a sov sit or I think it's just pro se. With elbow counsel. And he does okay in his previous proceedings, which we have followed. Third time's a felony where I live. Sarah Hartsfield starts next week in Texas, right? Can we just take a minute to look at the courtroom and say, wow, what an amazing courtroom.
I believe the state's got two witnesses. I'm not holding them.
Turn your microphone on.
That's the elbow counsel.
I think the state's got two witnesses, and I'm not going to hold General Bryson to that, or Mr. Vaughn's not either, but before Corporal Stewart's testimony, we may have a short jury out.
This happened yesterday, by the way.
On an issue, his testimony. But that, I think, should be the only thing that's taken up.
All right. Then you have some issue. There's nothing been filed to my knowledge that would affect that, but we'll take that up whenever it gets to it.
And, well, I can address the reason it hasn't been filed to now or later.
You what?
The reason that it hasn't been filed.
Go ahead.
It's because he's pro se.
Because I think it just probably came to light at the motion hearing. Necessariness for it. Necessary as to the necessity of it. I'm sorry.
All right, well, the jury's been sworn. We're proceeding with the trial. He's pled guilty to count 1. We will move to count 2, which is count 2 because we've obliterated the original count 2, and now count 3 is count 2.
We obliterated it.
So let's go ahead and put on our proof regarding that. And when you get to a witness that you need a jury out hearing, you will need to allow me to let me know, and then Mr. Vaughn can argue as whatever it is he wants to argue. All right, bring out the jury, please.
Just waiting for the jury. If you missed the verdict yesterday,
all right, thank you, ladies and gentlemen. We are now ready to proceed with the opening statements of the parties if they choose to make one. Or we can spoil it for you. Prosecution, step right up, argue your position.
You are going to get a snapshot of the incidents that happened on June the 22nd of 2022. The defendant having already pled to driving on revoked, the state will be presenting proof in our case in chief only on the charge of retaliation for past action. Now, what you will hear in the proof is that on that night, Officer Javins had a reason to stop and talk to Mr. Vaughn, and that Mr. Vaughn, the defendant, was arrested. You will be able to see the video of when he arrives at the jail and begins to make comments to Officer Javins. Okay. You will be able to hear his exact words. It will be up to you to decide exactly what those words are.
Oh, so we can't
Some
hear
of the
his
ones
exact
that
words.
will be fairly clear will be, I am a threat for a reason. Okay. When Officer Javins finishes up her paperwork, she needs to retrieve her handcuffs. When an officer arrests a person, those are that officer's handcuffs. And when that person is in the custody of the jail, it's normal that they switch out the handcuffs and put jail cuffs on, and the officer takes their cuffs with them should they need to make any other arrests. It is at that point that Mr. Vaughn is going to begin to become agitated, to become upset. He will state that he does not want this officer, a female, touching him. He will say that if they take the cuffs off, he's going to break her jaw. He will make several comments that you will get to hear while Officer Javins is there. And then later on, you will hear from another officer that will talk about comments later on. And all of those comments taken together will be the state's proof for retaliation for past action, which is the making of a threat against an officer for actions taken in the course of that officer's duty.
Mr. Vaughn, you may address the jury if you choose, or you may waive your argument.
I want to hear the argument.
Mr. Vaughn, do you wish to address the jury?
1 second, Your Honor.
If Mr. Vaughn is going to address the jury, he must do so now.
Yep. Stand up.
Your Honor, I wish to waive open statement and reserve for defendant's case in chief.
Right. Defendant has waived his right to make an opening statement, so, General, you may start your proof.
It's deferred.
State calls Corporal Lindsay Javins.
Confirm the testimony you give in this case be the truth, the whole truth, nothing but the truth.
Are you Corporal Lindsay Javins?
Yes, ma'am.
Now, some people say Javins instead of Javins. Is that right?
Yes, ma'am.
Can somebody move that?
We are ringing a little bit.
Yeah, I think it's me.
Would you spell your first and your last name for our court reporter?
Lindsey. My last name is Javins.
And how are you employed?
Oh, the City of Dixon Police Department.
And were you working for the city in June of 2022?
Yes, ma'am.
How long have you been in law enforcement?
Since 2017.
And is Dixon Police Department the only law enforcement agency that you've worked for?
No, ma'am. I previously worked for Fairview Police Department.
And on June the 18th of 2022, did you come into contact with the defendant?
Yes, ma'am.
And as part of that conduct, did you end up placing him under arrest?
Yes, ma'am.
We are going to focus on the events once he is taken to jail. So are you and he the only ones in your patrol car?
Yes, ma'am.
Were there other officers on scene earlier?
Yes, ma'am.
So once you arrive at the jail, explain to the jury sort of the sally port and how it goes to take someone into the jail.
Yes, ma'am. So whenever you pull into the jail, you drive around the side. There's a front gate. You press a button, tell them what you're there for. They let you in the front gate. And then you go to another gate, and that gate opens. And then you go into a sally port, which is essentially like a kind of like a pull-through garage. And it's a secure area to bring whoever into the jail. So we were in that sally port area. That's essentially like a garage. There's a door right beside where you would park your car to enter into the jail booking area.
On the ride to the jail, was the defendant, describe his demeanor.
On the way to the jail, like when we first started driving to the jail, we had been joking around and talking. We had just had a pretty reasonable conversation at the police department.
The defendant was joking?
On good terms at that point in time.
Is that unusual when you're transporting someone?
Yeah.
Not usually. I mean, after a point in time, sometimes people will, start having conversation with you. Sometimes people are mad the whole time. It fluctuates.
And did he remain calm or did he become agitated at some point?
He remained calm until we got to the sally port.
What is the first thing that you would pinpoint as him getting agitated?
Whenever he said that my name's not Lindsay, when he was getting out of the car, and then he said that I lied to him like all women do.
Oh.
And how did it go from there?
Not good.
So he is stepping out of the car. As he's getting out of the car, he said, "Your name's not Lindsay." And I said, "Yeah, it is Lindsay. My last name is Javins," because our name is on our uniform, and he saw the Javins. I said, "I just typically do first name basis with people because it's easier to remember than Javins. Javins is kind of hard to remember." So he started getting upset about that. He was like, he said that we had made peace, and then I had lied to him, something to that effect of that I lied to him about my name and that we weren't cool anymore, basically. And then as we start to enter into the jail, that is whenever he said, I'm a threat for a reason. I misheard him. So I said, what? You're a what for a reason? Or you know what for a reason? And he said, I'm a threat for a reason.
Is that the only thing he said that gave you concern?
No, ma'am.
Now, I'm going to pass up in just a minute a disc and ask you if you recognize it, and then give the jury an opportunity to view the video. But could you hit some of the high points of why the statements he made that were concerning to you?
So the first one that was bad was whenever the jail staff was trying to take the cuffs off of him. He was upset because I was assisting the jail staff. There was one person on his left arm and there was nobody on his right arm. And there was, who I don't even know the jailer's name. I presume him to be newer, kind of inexperienced, and he was standing just directly beside us. He wasn't doing much other than he was about to unlock the cuffs. So whenever Mr. Vaughn started pulling around, I went and grabbed his right arm, so just one officer wasn't assisting. At that point in time, he's upset because I'm touching him, and more deputies come, and whenever other people get there, I step back, thinking that if I'm no longer touching him, it's going to de-escalate the situation. And at that time, he said, when her jaw gets broke, it's your fault. And then he continued, fighting with them. And then a female jailer said, will you stop tensing up? We're trying to take these handcuffs off. And he said, excuse my language, fuck no, I'm going to beat that bitch up. Something of that effect. Then, probably one of the things that made me feel uneasy the most is after they got the cuffs off, they walked him to the jail doors for the holding area where they were putting him in. And he said, he looked at me and he said, laugh if you want to. You live in Dixon, Fairview, you talk too much, implying that I had told him too much information about myself, because I had told him that I'd previously worked for Fairview Police Department. So he was saying to me that I live in Dixon or Fairview, that I talk too much.
That's a threat.
So I told him too much information about myself.
Did he make any, did he call you by name during any of these threats?
During the actual threats, no. At one point, he did call me by name during the incident inside the jail, yes.
Was anything in his body language suggestive of who he was talking to?
Absolutely. There in several times he was speaking.
Objection, Your Honor. Speculation.
All right, restate your question.
I asked if there was anything in his body language that indicated to whom he was addressing with his threats.
Overrule the objection. She can testify about what she observed and what that led her to believe, but that goes to the jury to determine whether or not that's reasonable interpretation for what she saw.
Elbow counsel.
Officer, was there anything in his body language
whispering in
that
his ear
indicated to who he was speaking about?
Yes, ma'am. So he would, whenever he was speaking and he would say her, he was leaning towards my direction. One time he even looked at me, and there's another time that he's walking towards my direction and staring me down right before another officer grabbed him.
I'm going to pass up a disc. We will refer to this as Exhibit 1.
Ooh, I like this court because we get to see what's on video. Elbow counsel pretty much has his arm up to his elbow.
Do you recognize what I've just handed
using
you?
Him like a puppet.
Yes, ma'am.
What is it?
Like
It is
ventriloquism.
the disc that contains my body camera footage from that night.
And have you had an opportunity to review it?
Yes, ma'am.
Is it a true and accurate reflection of the events as they happened that night?
Yes, ma'am.
Judge, I would move this in as Exhibit 1.
We'll mark it as Exhibit 1.
And then after the clerk has marked it, I would like to retrieve it. Corporal Javens, did you, and you said that you reviewed it, you actually listened through this a couple of times, is that correct?
Yes, ma'am.
And did you take the time to prepare a transcript of what you heard on that recording?
Yes, ma'am.
Judge, at this point, when I play the body cam, actually, I'll pass up to Corporal, is this the transcript that you prepared?
Yes, ma'am, it is.
And to the best of your knowledge, is it a true and accurate reflection of what is on this recording?
Yes, ma'am. There are pieces that I think that is documented on there that it may say like we couldn't understand what he was saying. There's some things that, especially at the end, that you couldn't hear exactly what he was saying whenever he was in the holding cell. There were only a couple comments that you could actually make out. So it doesn't have every single line, but it is pretty accurate to what's on here is what I heard on the video.
Judge, I have previously provided a copy of this to the defense. I would like to move it in as Exhibit 2 and allow the jurors to have a copy as they listen to the recording.
All right. Ladies and gentlemen, this is a transcript this witness has prepared based on her interpretation of what you're hearing, about to see and hear on this recording. It is up to you to compare that to what you hear on that to determine whether or not that is an accurate transcription.
I think I've tuned out that little ring sound from the courtroom. It's difficult. By my best estimation, it's coming in at 154 hertz. So if you guys have a better tone ear than I do, please let me know and I'll tune it out. The hertz of justice. Okay, should be playing here. We're trying to count objections. So I'm going to get the objection counter up. Is this it? Yeah, that'll work. I like to hum in court. I need to move it. The counter is off center. I need to fix that. I'm sure you all noticed already.
Sorry, Judge, the state of Tennessee's firewall was not playing nice with the video.
Blame the state. There we go. Now we can center it. One objection so far. It's not playing yet. She's still trying to get it connected. Jamie had a dream last night that she called me twice on the air and I didn't like the question, so I hung up on you twice. That sounds more like a nightmare, Jamie. I don't hang up on many people.
Reboot what? What are we rebooting?
The firewall? Watch her say, just ask the court tech guy turn off the firewall so my video will play. That's not the right answer. It was rude. I unsubscribed. Oh no. Oh. I like watching lawyers have tech problems. Because I could fix that.
Ladies and gentlemen, since it looks like we're in a stalled here for a moment, why don't you step across, leave those copies of the transcript in the courtroom and go ahead and step over to the jury room, and we'll call you when we have everything ready.
Jury steps out. Judge might reprimand them just a little bit. I don't know why he'd kick the jury out unless he was going to say, "Look, you can't be like this." It's probably ready now.
General Bryson, I'm going to step off. As soon as you can get that in working order, let me know.
We're going to skip ahead because we can. Wait for the judge to come back in the top left-hand corner. Oh, there he goes. Okay, it looks like they've got it figured out. We've got video down at the bottom. Just informed the judge. He'll be back out. We're waiting for elbow counsel as well. Next time it's a slow court week.
How long?
Tanika's 2 cents to fill us in on what's happening with Sarah Boone. I probably should do some more collaboration stuff.
Nixon Chantry on the 31st. 1, 2, 3. I just thought it was only supposed to be 3. (28th of October).
I have it.
Okay. So what are you asking? You said
That's what I wanted to make sure you have it.
You can put it down, say 4 days. I'd actually given that day out to some chancery cases in anticipation that maybe it wouldn't take the full 4 days. Sounds like that's not going to work.
And, that was a plea.
This is not the discussion about this particular case. They're trying to get some other stuff sorted out right now. Well, they're still waiting for elbow counsel to show up, so we're going to zip forward while we wait for elbow counsel. There he is. He just walks in right here.
Judge, I'll go ahead and say for the appellate record, there are 2 files on this. Yep. For the appellate record, there are 2 files on this, and I will be playing from the second file. And then I'll put my times on when the jury comes in here.
Wait for the jury now. I don't like waiting.
Time, so that would be the real date for me to begin playing.
We are ready.
Okay, there we go.
Judge, for the record, I am beginning to play on the video screen time, so that would be the real date and time at 22 hours, 27 minutes, and 8 seconds. And I may pause at points. I'll note that for the record.
We're in the Sally Port. She locks up her firearm in the trunk as a standard procedure. Close the trunk.
Can we get out this way or on that end? Whichever one's easiest for you.
Your name ain't Lindsay.
That's my first name. My last name's Javins. Javins.
Like all women.
My name is Lindsay.
I just gave you respect. I'm taking
Lindsay Javins. Look, I try to be like first name basis with people. Lindsay's way easier to remember than Javins.
supposed to do.
Yeah, like Lindsay's.
And when y'all got the last time on the lawsuit, you're straight.
What do you mean?
I'm gonna use you first. I'm gonna let you know. Don't play with nobody that's peaceful.
They didn't close the Sally Port door?
I'm not blaming nobody was peaceful. I was being peaceful until you wouldn't get out of the car.
Disrespectful as I was.
Come on, man.
I'm a threat, though.
Come on, man.
I'm a threat for a reason.
What?
I'm a threat for a reason.
You know what for a reason?
I am a threat.
Oh, you are a threat?
Yes, ma'am.
Okay. I don't know how you mean that, but okay. What did I lie to you about? I'm not playing with you.
I don't trust women for a reason, bro. Hey, for real.
I don't trust people that don't listen to me. I've never given them. Look, how are you going to tell me we made peace and then start being mean again?
I'm just letting you know. I'm just letting you know who I am. It ain't no threat, not my kid.
You kind of just threatened me, but it's cool.
I'm still on none of it. Tell me some feels up your stomach. Whatever it is. Fuck feelings. That's what involved the whole already. Your feelings.
All right.
Actually, right.
You're taking them really spicy. I don't have any problem over here.
Mm-hmm.
Let me crank the audio a bit. Might get really loud. Filling out the booking paperwork. Usually protocol is when you pull the car into the Sally Port to bring a prisoner in, you close the Sally Port door first so they can't run and escape.
You still go through, you still put it in a supplement.
Who's the sergeant in charge, man?
It's Gonzalez.
Is it the light skin dude?
Huh?
Is he light skin? I call him light skin, okay.
Feels like you're like creeping up here, like you didn't know what you were walking into. You looked a little scared.
Never scared.
Nobody else. I see it. That's fucking reading.
We're using the copy machine. It's fast. Got a nice one. Good. Staple and collate. She means business when she sorts papers. I don't know what she's doing, but it seems really efficient. Okay.
Mr. Vaughn, you can take those off.
Don't do it.
I would just try calling back in about 30 minutes to an hour. We won't know really anything
Mr. Vaughn,
about it.
I gotta leave. Take the cuffs off. I need my. Get this fucking guy. I'm leaving, guys.
Yeah, you can call them. I can tell them we're goodbye and they might have some information to give you. But otherwise, I would just call back in about a half hour.
Oh, what?
All right, listen. I'm just talking about, listen. I'm gonna be cordial. We'll be frank.
Well, because that's my stuff. I need my
I
stuff.
don't trust her.
That's her cuffs.
I will put myself in your country and we can go to this cell together. She needs to be away from me. I'm asking you not to take these cuffs off.
Mr.
Until I
Vaughn.
get away from her. Me and you can walk over there. You tell her to leave me alone. I will not
However you
cause
want
you
to do
any
it.
trouble.
I
Fuck
just
the
need
rest.
shit so I can go.
Fuck the rest. Play with me if you want to and find out.
I'm sorry.
Everyone's watching. They're like, oh, there's a
Go
show.
and get the keys. No, you're not going to move. I'm going to remove these cuffs off you. Stop pulling back now.
Pulling back. Why is she touching me? A female shouldn't be touching me.
now!
A female shouldn't be touching me, bro. Look, I'm scared. I'm in fear for my life. She should not be touching me.
Hey, nobody wants to hurt you.
Why is she touching me? I don't trust her. Get her off of me.
I hear you.
Please get her off of me.
Nobody wants to hurt you. Just go with the flow.
Go with the flow. Get her off me. I don't need her touching me. Y'all can handle me. I said I wouldn't.
Nobody's touching you anymore.
Stop pulling back!
She fucking touch me.
She's not touching you!
She fucking touch me. She's not touching me.
She's not touching you anymore.
She's not touching me. Relax.
She's not touching you.
Relax.
Her hands are off you right now.
I just told you I would. I'm gonna give you no problem. She ain't got no goddamn reason to touch me. When I don't get broke, it's your fault.
Give a fuck about the law.
Sorry. Hey, we're trying to get the cuffs off you. Can you stop tensing up, please?
Fuck no, because I'm going to beat that bitch up. Yeah,
There's the threat.
thank y'all. Think everybody playing. You laughing. You live in Dixon, family, talk somewhere. You get the problem. Where you shake me up, bitch.
She's laughing.
I'm sorry. He just wants to act bad since he's in here, because he's perfectly fine the rest of the time. Just trying to act hard. Here's his copies right here.
He's trying to act hard.
That's all he had, was just whatever was on.
Just shoes.
That's all he had. Didn't have anything else.
She likes doing this. They have to be perfect, the right size, and flipped
There's
opposite
no
directions.
comfort in this. Like, he was threatening to kill his kid.
Whoops. Objection.
Judge, we have stopped play at 22 hours, 37 minutes, and 59 seconds.
All right.
Judge,
Wow.
I am going to keep this queued up in case during his cross-examination, the defendant wants to play any portion of this.
All right, then we'll turn the lights on.
Did this interaction at the jail happen in Dixon County?
Yes, ma'am.
Did you have you had any interaction with the defendant outside of your capacity as a law enforcement officer?
No, ma'am.
These comments taken as a whole, did you mention this to another officer?
Yes, ma'am.
And that officer encouraged you to document these?
Yes, ma'am.
Why did he encourage you to document these?
He encouraged me to document the information.
Objection, Your Honor. Speculation.
Overruled.
Why did he encourage you to document these?
He encouraged me to document it in my report just in case any further action happened, as if he did try to retaliate against me, did try to assault me or anything like that. Say if I, saw him out in public somewhere.
Let's talk about assault. You did not seek charges for him on assault that night.
That's correct.
And that's because he didn't hit you that night.
Yes, ma'am.
And that is a different legal charge than the retaliation.
Yes, ma'am.
Objection, Your Honor. Leading.
Sustained. Don't lead the witness.
Sustained.
The charges of assault and retaliation, do those have separate elements?
Yes, ma'am.
Nothing further.
Mr. Vaughn, do you have the right to cross-examine the witness? Do you wish to ask any questions?
Yes, sir, I do.
This is the time you have to get up. Just take it all with you. Mr. Vaughn does surprisingly well as a pro se. Like, he understands the flow of
Good
court.
afternoon. Is it Corporal Jarvins?
Javins.
Javins, sorry about that. Is this this is a testimony you wrote, correct?
That is, yes, sir.
Here,
I would say it's a testimony, but it's what I wrote, yes.
Okay. This was because the video was, it was difficult for you to hear, correct? The reason you wrote this?
I wrote it out for myself, and then I shared it with Miss Bryson, or General Bryson, sorry.
So you needed to recall it better for the jury, correct? Yes.
No, sir, I remembered what happened.
You, how long ago was this?
In 2022.
Okay, you remember what happened. Are you sure you didn't just write this out because you forgot what happened and you just wanted to, so I'm sorry, excuse me. I'm brain farting here, I'm sorry.
Okay.
So,
She's
you
all,
wrote
you're
this
okay.
out
She's encouraging him. You're all right. Take your
so
time.
that you wouldn't forget what happened for the jury, correct?
I wrote it out while I was reviewing my video. I think that it's important that I did that because there were a lot of direct statements that were made that I think the accuracy is important.
Okay, so you remember it from the video or you have firsthand knowledge?
Yes, sir, from the video.
Oh, okay. So
this is not firsthand knowledge?
So you only remember the threat and for retaliation from the video? Or, I mean, because let me ask you this instead. So you arrested me for retaliation. No, you didn't. I was charged with retaliation, correct? Retaliation and past act.
Yes, sir, that was presented to a grand jury and it came back with a true bill.
So that wasn't the original charge, was it? That the reason I was arrested and taken to the jail, was it?
No, you were taken to jail for a different reason.
Okay. And you didn't charge me that night with retaliation and past act, correct?
No, sir.
Okay. Did I tell you that I was scared of women at any time during the traffic stop?
Yes, sir.
I did. Did you believe that to be true?
Not entirely, no, sir.
Oh, so you took it as joking or lying per se?
I didn't believe that you were scared of all women, no, sir.
Okay. Was there another female jailer present who had her hands on me at the time when these statements were made? When they were trying to remove the cuffs?
Yes, sir. Yes, sir.
And you didn't never hear me say your name at all or direct that towards you, that I want to do anything to you?
You looked at me and you said, Lindsay, if that's what your name is, because you were upset because you thought I lied to you. And then during that time, that between the two threats of breaking my jaw and beating me up, you called me a lying ass hoe or lying ass bitch, one of the two.
Okay. That happened.
Your Honor, can I ask my question, please?
You may consult. Ladies and gentlemen, for further explanation, Mr. Spratt was appointed by this court as advisory counsel. He is not participating on an active basis, but he's there to give advice because of the fact that Mr. Vaughn had requested to be able to represent himself. So.
I think he's more active than the judge thinks in this one. I think Mr. Spratt is pretty much controlling the puppet, so to speak. He got a good line of questioning in there, asking if she had firsthand recollection of this, and she's like, "No, I only remember it from the video." That was good.
Okay, in the video we just watched, I'm sorry, your name is Miss Jarvin. So Jarvin, you got to keep forgiving me for that. I'm horrible with names.
You're fine. Last name is Javins.
Just call me
okay.
Lindsay. Just call me.
The video we just watched, you said he's trying to act bad because he was in there before and he was perfectly fine the whole time. You said that, right?
At the end, I made a comment that you were acting different than you were before we got to the jail. Absolutely.
You were laughing too also, right?
Yes, sir.
Okay. So you felt no threat at the time at all that night, did you?
Threats were made to me, yes.
So you didn't feel threatened?
I did feel threatened.
But you're laughing during feeling threatened?
I think that a part of my job, we are frequently faced with fear that we don't show. I've been faced with life and death situations and I didn't show fear.
So you had no threats or interactions with me since then?
The only interaction I've had with you since then is in court.
I think this would be safe to say that I feel like these charges were a retaliation from you instead of from me due to the fact that you arrested me for illegally.
Make it a question.
Mr. Vaughn, you are making a statement rather than asking a question. It has to be in the form of a question. You'll be allowed to testify if you choose to do so, but this must be in the form of a question for this witness.
Okay. Would you say that the original arrest was illegal?
No, sir.
Let me see here. I got some more questions for you. What was your original charges you arrested me for?
Originally, you were charged with resisting arrest, stop, halt, frisk.
Hold on just a second, please. Ladies and gentlemen, step across the way, please.
Jury out again. Judge can explain the law real quick and see what can of worms we're opening right now. This is Jeopardy rules. Put it in the form of a question. He said, would you agree at the end? But it was a statement. It needs to be worded more of a question.
Okay, we're walking a fine line. You've asked her a question about the original arrests. The original arrests were for driving on a revoked license, third offense, and for the second count, which the court, I think, state resisting arrest, which I think the state had acknowledged. My concern is that opening the door
to that third offense,
the evidence coming in about you're having two prior, being driving on a revoked license, third offense, and that's why I wanted to caution Corporal. I just want you, if you can answer his question about driving on a revoked license, just don't add the third offense part.
Okay.
Is that all right?
Yes, sir.
All right. Then that's the only thing.
Even though he basically opened the door.
Step back and talk to your advisory counsel.
I was going to tell you, don't go there. Don't go there. I'm gonna skip through these advisory council things because it's a little bit slow. How do you think he's doing so far? Time to talk to your elbow. Yes. What, if any reason, did you have to arrest me? Well, third time. Oh, judge left. How did I miss that? And prosecutor left. Everyone's leaving. There's judges back. Wait. I went back too far, sorry. Skip ahead. They get up, they talk, they go to the podium, and then the judge comes back. Okay. We're going to skip through all this so we can get through it quickly.
Brad, I'm going to give you some leeway and from these, but I'm not going to keep delaying this trial for you two to confer. So make it quick.
If only he had another elbow. Or if his elbow was just closer to his head.
I understand. And that's why I'm simply advising you both I'll give you an opportunity to consult. That's what elbow counsel or advisory counsel does. But there is a point where it's delaying the trial, and we're not going to continue to allow that to keep happening if it's going to be.
I had Captain Crunch cereal. Probably not healthy, but it tasted great.
That's fine. As I say, I'm not complaining. I'm just saying it's already almost 2:30 in the afternoon. So, what happened to our district attorney?
We sort of need somebody on the prosecutor's table before we can proceed. This is very telling already in this trial. Very early on, the jury's only been here for less than half an hour. The judge is already mindful of the time and how long this is taking.
All right, gentlemen, we're ready for the jury.
Yes, Judge.
Bring the jury in.
Excuse me, Your Honor, 1 second. I'm aware of the charges that I'm being charged with, and I don't want to hinder her from responding to my questions. I mean, they're going to have to know that what I'm arrested for anyways.
It's your decision as to how you ask. I'm just wanted to make clear that what you're opening the door for, and you go for it. You ask whatever questions you feel like you want. You've got counsel that's advised you, and now you're ready to go.
He's like, Your Honor, if you wouldn't mind, is it okay if I kick the door in to my own detriment? Judge says it's your funeral. Go ahead. Counsel didn't say we want this to come out. But I think his mindset is he's trying to prove to the jury that the arrest was illegal. And so he needs to go there. He needs to sort of get all the facts about the arrest in. I don't think the arrest was illegal just because they dropped the charges and decided not to prosecute. I think they had met the standard of proof needed for an arrest, even though they didn't have
I just was trying to take a head count
for a jury conviction.
Right. I guess I could just count the empty chairs instead of the heads. All right, Mr. Vaughn, we are ready for you to continue your line of questioning.
Okay. What was the original reason you arrested me?
Resisting and driving on revoked.
Okay. Was one of those charges dismissed?
The state elected to not proceed forward with one of them, yes.
Okay. Do you believe that I really was resisting that night?
Yes, sir.
Okay.
That's why I charged you with it. That's why we charged.
Ron,
That's
I would
why I
like to-
arrested you.
What did you
Briefly.
Sir?
If you need to consult, is that what you're saying?
No, I'm gonna play some video
Oh,
footage.
you want to play the video?
Yes, sir.
All right. Mr. Spratt can assist you in that.
All right, here we go. We get some more video. Looking at a file management software. Here we go. Ooh, right at the beginning. Cruiser cam. No, it's actually body cam inside the cruiser.
So are
But
you
look at
going
those
to
buttons
ask
and
this
controls.
witness, what is it we're watching so that the jury understand and can follow along?
This right here, jury, is the beginning of the interaction with Miss Javins. I can't get it right.
Right. So you're going to show the body cam footage from the initial contact between you and Corporal Javins?
Yes, sir.
All right.
Judge, for the appellate record, this is the first file on the disk that is submitted as Exhibit 1. And we are starting at the beginning of play, and I'll note the time whenever they stop.
All right. Thank you.
we're pulled into Dollar General now.
Dollar General. Your door is ajar. Whoa. Kill the music. Oh, we're going to get us. I've got to mute this.
How you doing?
How are you doing?
How about I come back here and talk to me real quick, man?
I'm not stepping out of the vehicle until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk to you about
A call
what's
for a
going-
domestic? What makes a domestic?
I got you. Somebody just called. Let me come back here and talk to you real quick. We'll talk about
I can't step out of the vehicle until I commit a crime. I reserve all my rights.
All right, well, let me tell you this. So Pennsylvania versus Mims case law says anytime I tell you to step out of the car, you step out of the car.
But you also know that
Case law says, no. Case law says if I tell you to get out of the car, you get out of the car.
Can I have a male? Can
get
I
out of the car.
come to the room?
Well, they're coming. You're going to get out of the car when I ask you to.
I don't feel comfortable right now because there's a female person and it's a male domestic. I've been in this 3 times.
I'm just trying to talk to you. Okay. You're making this a thing.
No, I'm not.
Step it up for me.
Step it up for me.
I don't want to talk to you. I want to talk to you separately, okay? That's how I want to do it. That's how we do domestics. We're going to talk to you separately. That's how we're going to go. So I'm going to get you to step out of the car. Look, this is go one way. You're going to step out because I'm telling you to step out now.
Where am I going to stand? And am I under arrest before I step out of my private vehicle?
You're not under arrest right now. I just need to talk to you.
I have no reason to step out. I'm still not under arrest.
Step out. You're going to go to jail for resisting. The second I put my hands on you and you don't get out of this car, you're going to go for resisting.
You did not answer correctly. You know this.
There ain't nothing about it. I just told you.
I'm not under arrest and you have no reason to touch me.
Case law says if I tell you to get out of the car, you get out of the car.
If you say I'm under arrest,
get out of the car. Come on. Get out of the car. Get out of the car. I told you to get out. Get out of the car.
Don't get out.
Get out.
Well, hold on. Grab that before you touch me.
You're good. I ain't worried about that. Come back here and talk to me. Stop making this a thing.
Is that a male in that car?
Yes, there's 2 males in that car.
Look, I want a male to touch me. Please stop touching me.
Go up here. Go up here.
I want a male to touch me.
Yeah, there's going to be a male that's going to touch you. Put your hands on your back.
Please touch me.
There's going to be a male that's going to touch you.
A male, please touch me.
All right.
There are no females to touch me.
Dude, chill out.
See, you're being disrespectful.
You've been disrespectful since I
asked you, am I under arrest? You said no. It ain't no shut up. Am I under arrest? You said no. Why am I detained?
Did I tell you to get out of the car? Did I tell you to get out of the car?
Am I under arrest? Am I under arrest?
Did I tell you? Now you are.
I reserved on my arrest.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
No, you're not.
No, he's not. No, you're not.
Right now, I think you should go.
All right, ma'am. You step out and talk me away from the kids, please.
Yeah, we were just arguing.
I got
We've been
you.
together 15 years.
I got you. Well, there's enough that's already. Listen.
Lights up. Camera back to the witness.
For the record, we have stopped at time signature 20:53:54.
Okay. Are you familiar with the de-escalation process?
Are you?
The de-escalation process.
Process or policy? Yes.
I'm not sure what you're asking.
Do your department have a de-escalation process or policy?
We're trained on de-escalation, yes.
Okay. Would you give me some idea what that looks like, or from your training? What did they teach you how to de-escalate a situation?
It varies upon circumstances and what's going on. I think that talking to people, I feel like it's a de-escalation tactic of talking to people like, hey man, come out here and talk to me real quick so we can talk about what's going on. That, explaining to people their legal obligation to do something and giving them prior warning of, if I have to put my hands on you, you're going to jail for resisting. I think all of those things de-escalation works 2 ways. Gives that person a chance to begin to comply.
Okay. You just stated that citing their legal obligation to do something, correct?
Yes, sir.
So you cited Men's versus Pennsylvania, correct?
Pennsylvania versus Mims, yes, sir.
Okay, so you're familiar with that case law, correct?
Yes, sir.
But you're not familiar with past act retaliation? That is a statute that you can charge somebody with?
What are you asking?
I believe earlier you stated that you didn't have knowledge of what the charge was, but you just took note of it in case something happened.
I took note of the threats. If you're referring to the last motion hearing that we had, when I said I was unaware that that was a thing, I was unaware that it was applicable to law enforcement. I didn't realize that we were covered under that statute. I thought that it was applicable for judges and DAs and things like that.
Yeah,
Or positions like that, I'm sorry.
Yeah, I'm sorry. I'm just finding it funny that you're familiar with case law, but not with.
Objection.
I'm sorry.
If we could keep to questions instead of statements.
You're making statements, Mr. Vaughn. Sustain the objection. You may only ask questions.
Okay. Let me see. Did I have a seatbelt on that night?
Yes, sir.
Did I have a knife or anything else on me?
Yes, sir.
Okay. Did I give you the knife?
You told me the knife was in your pocket, and I took it out and put it in the car before you got out.
Do you think that was a wise thing for me to do? To let you know I had a weapon on me?
I appreciated that.
Okay. Did that make you feel at ease? You wasn't feeling threatened any type of way?
I appreciated that you told me you had a knife on you so we could remove that from your pocket, yes.
Okay.
Wasn't charged with any weapons offenses.
When you're arresting someone, is it procedure for you to tell them to shut up?
Tell people to shut up?
Yeah.
I mean, it's not typically something that I do, but in the heat of the moment, I may say things that typically aren't said.
Okay, so the heat of moment, would you mean like you were agitated maybe?
I wouldn't say I was agitated. I was at a different level than somebody who would have complied and got out of the car and just sorted things out when I first asked them to.
Would you please elaborate on a different level, please?
A different level as in my senses were heightened that something else might be going on, that something's wrong. I have those officer safety concerns in mind because you weren't acting like the typical person does whenever you make a stop and you say, hey, come back here and talk to me for a minute. That's typically not the response that we get.
Okay. Here's one more question. I think we asked this before, but just for the record, for the jury's ears too. What was the original call? What was your reason for pulling me over?
The original reason was for domestic. They called in and said that you were threatening to kill the female and the children. That person was so concerned about those threats, they even came to the scene to speak with me because she was so concerned.
Okay. I'll ask you next. And that's the charge you didn't charge me with, correct?
No, sir, you were not charged for domestic.
Okay. I have some more videos I want to play, Your Honor. We can move forward.
What videos are those?
I have actually off the same video. I got different parts of it I want to play for the jury.
All right. Mr. Pratt, are you going to assist you in that?
Yes, Your Honor. I believe he's got some marked, and I'll flow with him and let you know for the record where we're at.
What?
Judge says roll tape. Let's see it. Please no music.
So, Your Honor, for the record, we're starting back at 20:55 and 57 seconds. 20:55 and 57 seconds on the timestamp.
It's not besides the point when I'm in fear. All right, man. I'm in fear of females because look, in 2015, 5 females showed up to the scene.
Bro, come on now. Stop that. Stop that.
You have not been where I've been. I don't know you. You're a new buddy. I'm not, no disrespect to new buddy. I've been doing this for years.
Okay, so
no disrespect.
What happened at Walmart? Why are people
All I told her was shut up. I got a phone call with people that are very dangerous telling me that my baby mama had her mouth open on their situation. I said, baby, You cannot talk. And she's still cussing me. She's doing everything. Look, shut up, shut up, shut up. All I'll repeat.
Yeah.
I've been with her for 15 years. She still ain't learned to shut up. I don't ever put my hands on her. I don't ever do anything. Look, I just bought that for her. It ain't even her birthday.
I didn't say you put your hands on her.
I'm scared of females. I'm just gonna let you know because females make situations worse.
Oh, yeah.
That's why you heard me keep asking for
help.
help.
It sounds like you made the situation worse by yourself whenever I told you to get out of the damn car.
But you're a female.
I tell you to get out of the car and you wouldn't get out of the car. That's the bottom line. I explained to you. I explained to you the law. I explained to you. If I tell you to get out of the car.
Listen, man, when it comes to life,
law means nothing. Oh, I'm sorry.
When it comes to my life, I'm sorry, but when it comes to my life.
Okay, and that's why you go to jail.
I've heard that before.
Okay, and that's how you go to jail, is if you don't follow the rules, then you go to fucking jail.
Your Honor, for the record, we've stopped at 20:57 and 21 seconds.
All right.
Says that doesn't
my
trust
next question would
females
be-
because females make every
All right, so-
situation worse.
Would you consider this an investigation still into the domestic at this point in the video?
I had spoken to the female about the incident. I was attempting to speak to you about the incident, and if I'm not mistaken, it continues. And you said that, no, you just told her to shut up.
What I'm asking is this considered an investigation at this point in the video? This is what you're doing, correct?
Looking into the domestic, yes, sir.
Okay. All right, interrupting people while they're speaking, is that part of your training? Because you walked up in the video when I was talking and just started cutting
Judge,
people off.
again, questions, not statements.
The objection is to the to the fact that you're not asking questions, you're making statements, and I sustain the objection.
Is interrupting people while they're speaking a part of your training?
No.
Okay. I believe we just seen that in the video, correct?
Interrupting you from speaking to the other officers, is that what you're speaking of?
To them, including you.
No, that's not something that they train us on.
Okay. What about profane language?
No, they don't train us on that either.
We learned that on our
In the
own.
video, you're going to fucking jail, did you not?
I believe so.
Okay. What about the response? It doesn't matter what you think. Is this the proper response to people when you're investigating a domestic?
It doesn't matter what you think.
Yeah.
Six minutes, 31 seconds.
Oh, yeah, that was definitely in there.
I'm not 100% sure what that was in response to, sir.
I believe we can play the rest of that video now, Your Honor.
Here we go. Roll tape.
All right.
Officer's like, the judge is like, this isn't helping you as much as you think it is. It's making full use of the rolly chairs. There's an expectation of
Your Honor,
professionalism required from police
For the
officers.
record, this will be from 20:58 and 20 seconds. Starting back.
All right.
So blunt splitter, or what is that? Temporary.
Blunt splitter, you see how that's disrespectful?
Yeah, what is that?
Charging you? I don't
splitter.
want to talk to you no more.
Okay, well, you're going to jail for resisting.
Resisting? I didn't do anything.
Did I tell you to get out of the car?
I told you I reserve my rights. I asked you the reason. That's my right.
Did I tell you to get out of the car? Did I? You know, why are you doing all that? Stand up.
I'm scared of you. I told you I'm scared.
Stand up. Quit acting like a grown man, man. Act like a grown man. Come on, come back here. You're making this a thing.
It is. If you've been beaten, you have to look in your life.
Yeah. Let me fix this.
What
happened in the past is whatever. We're here right now.
We're not trying to
beat the shit out of you.
I'm scared of you. I keep saying I'm scared of you.
You ain't scared of me.
I am.
You ain't scared of me, man. Come on. You are not scared of me. Get in this car. Oh, shut up. You are not scared of me. Like, not even the slightest bit.
You can't change my words. You can take them and do whatever you want. I am scared of you.
All right, get in the car.
You're a female. I'm scared. Y'all make whatever y'all want to make.
Get in the car.
I'm with a white woman. I'm a black man. I'm scared of you.
That shit don't mean a damn thing to me. I don't give a shit about color. Get in the fucking car.
You don't, but I do.
Okay, get in
it's
the car.
my life. You ain't been where I've been.
Get in the car. All the way in.
I'm trying.
There you go. Cool. Yeah. Okay. Told him to get out of the car. Explained to him Pennsylvania versus Mims, everything. Told him to get out of the car. Told him to get out of the car. Told him to get out of the car. I had to open the door myself. And then I had to carry him out of the car because we wanted to play games.
Roger that. So she's not being...
She isn't being cooperative. He's not being cooperative. He doesn't want my services for his domestics. So
she said at the beginning, I said, look, we got a call dude who's starting to kill people. She's like, he's just talking shit. He wouldn't really hurt anybody. And then near the end, I was like, so to be clear though, like, you did threaten me. She was like, I don't remember him saying that. I'm like, okay.
Will you do my paperwork for me?
I found it.
Yeah.
I found the tone.
I'm sure one of us.
Take it out.
He got a wallet in here or not.
That one's at 742 hertz.
He got a wallet in here?
A wallet? No.
No. He don't have an ID?
I'm not 100% if it's in your
What's that right there? Is that your ID? Oh, okay.
That's my license.
I got you.
I broke it a little.
What's his name?
His name? Did he give it to you?
No, I haven't got it from you. He's terrified of females apparently, so.
What is his name?
What's his name?
Yeah. Okay, I'll go ask
Like,
him
I don't
myself.
get why y'all need.
I was just trying to get it from you because you're like a little more cooperative than he's being, so I'm.
I'm sorry about that. Like, I'm trying to. I don't want him to go to jail.
What's tatted on
this
your
is
arm?
stupid.
Because that's kind of funny.
Well, I don't want him to go to jail.
Okay, well he's going either way. So.
What was he going to jail for?
Can I see that real quick? I'll just use it by your DA.
It's kind of broke.
For resisting, 'cause I told him to get out of the car. He didn't get out of the car. 146 Central, Tennessee D on ready. Will you try to get his info?
Yeah.
Thank you. 106 626 651.
I'm gonna lose it again.
They're all good.
I lost him in about 3 weeks one time.
Listen, I'm not trying to be rude, okay? I'm not trying to be rude at all. We were called. They're saying threatening to kill you and the kids and everything else.
Ask them. Hold on.
No, you're good.
Ask them.
No, we ain't gotta do all that. What I'm saying is, I'm here for a reason. Like, all I gotta do is make sure that he didn't beat the shit out of you.
No, I mean,
or beat the shit out of the kids.
We're not bleeding. He can't even get back there to the kids because all the shit and all. You
As
know?
long as that's not going on,
Like, no.
then I
He
give
ain't
y'all
put his
some.
hands on nobody. Yes, he talked shit. Yes, I talked shit.
that's
Yes,
what
we
I'm saying.
yelled. But he ain't put his hands on nobody.
It's not.
They're fine. We're fine.
It's not illegal to argue. Everyone argues. What I'm saying is, we don't have to make this a thing. Any type of situation like this, it doesn't matter who you are. I'm gonna separate the people and talk to you. Okay? So that's all that was happening. That's why.
I think I went to school with you.
Yeah.
That's why. That's why we're here.
Weird time for a high school reunion, but when you recognize somebody, you recognize them.
You want to tell us who he is?
No, he will, but so his name is actually Sherry. He pronounced it Cedric, and he spelled it like he didn't really give a fuck. Alright, so I was trying to copy it down while he was doing it, so I was asking if that's spelled Sherry. S-H-E-R-R.
You got a social? Just get a social. That's the easiest way. Go ahead. 146.
Yeah, this thing started out as a joke, and it's just got out of control now.
Apparently somebody in Walmart called. They were getting lippy in Walmart with each other, not physical.
Did you get it?
Somebody called. Police rolled up, stopped them as they left Walmart and pulled into the Dollar General. And that's where this happened.
That's why I'm asking.
Yeah, that works.
475.
That's your whole social?
And you can't find it because you're already a member. It looks like you've been gifted one. Congratulations.
Like when I tell y'all upstairs.
You said that's way too many numbers.
You have to wait for this one to expire
That's
before
her, she
you
knows.
get it.
I know, that's what I'm trying to figure out, man.
She won't tell you who
You just tatted on her arm. It's not funny, but.
which you shouldn't ask me, bro. Like, we have no games to play. There's no problem. She told you. I told you.
What is?
No. What, so just because that name's on her arm, though, right? That don't mean it's you, though.
I'm
It
telling
could
you,
be
on record,
a different family member.
That is me.
Okay, I believe that. I'm just saying, when I first saw it, I'm thinking that could be a family member. I don't
All
know.
my kids and everything.
Okay, so, all right. So, what's your date of birth? We'll just do that. It's easier. You know when you were born, right?
Don't celebrate birthday.
89, 33. 89.
Try
You
it.
get all that now?
613.
I tried. I'm trying. Got all sorts of numbers in there. Not sure what it is. Start the paperwork.
Is there some relevance to watching her pull out the paperwork that we need? Stop the video.
Yeah.
I mean, I understand it may be an hour or more that we're going through this. I'm just trying to determine, is there some portion of this that is relevant to the issues that the jury has to decide?
Yes, I have some questions that pertain to everything that's marked. It shouldn't be much longer.
What is? Your Honor, my list shows about 8 more minutes.
All right.
8 more minutes of this. What's your birthday? I don't celebrate birthdays.
He's terrified of me, apparently.
Pretty intimidating.
Man's solid muscle. Not at all. He's like solid fucking muscle, man. Solid fucking muscle. Solid muscle.
SFM. Apparently that's a thing.
That's probably.
That's different though, man. Come on.
Yeah. That's why.
Could never be a cop for this reason. Too much paperwork. This could be why the city or county
Yes, ma'am.
elected not to
Okay, yeah.
pursue charges.
Cool, perfect.
I have my boyfriend on the phone who heard all of it.
Okay, what happened?
So you can
Walmart.
tell she's pregnant, right? He pulls in absolutely just screaming at her over who knows what. But then he's like, I'm gonna kill you and those kids behind you. And then he's like, I'm gonna get my sister.
Where was this at?
So
I'm in the parking lot?
Yeah, on the worker's side. I don't have any doors on my Jeep, so it's like I can hear everything and anything. But he's like, I'm gonna kill you, I'm gonna get my sister to kill you, I'm gonna drag these kids, I'm gonna kill the kids. Talks about hitting her. Like, I even have my boyfriend on the phone too who can contest that he heard all of it too. He's talking about killing her and the kids and like I don't know how to describe it, like pushing her kinda. Like that nudge pushing her, and he was like slamming her and the doors on the car and like just going at her.
Okay.
But like, and didn't you hear all that?
Do you need DV paperwork?
I do. That's what I was trying to do. Go get that.
But like,
I started.
my boyfriend on the phone. He heard it all too.
I think she's gonna cooperate.
Yeah, but she got in the car, so it probably was a normal thing. But like,
Yeah, she's not being very cooperative. Like she won't tell me much. So, and neither will he. So.
yeah, but yeah.
So he was like threatening to kill the kids.
No, he was threatening to kill the kids. And like I was shook. I went and told my manager too, like what happened after I called y'all. But yeah, I saw the lights. I was like, that's probably them. So
Yeah,
I
did get him stopped, so I do appreciate you calling.
but he was like threatening to kill
Do you happen to have your ID on your second log that you were my complainant? And that I had like legit reason to make contact with him, you know?
GG Share Bear member for 24 months.
Yeah. Yeah, but he was like going at her. And like, don't get him.
Sweet. I appreciate you calling for real.
Like, yeah. No, other people saw in the parking lot.
Apparently, multiple witnesses. The boyfriend on the phone heard it over the phone. She saw it as
As
it
far
occurred in
as
the
like
parking
Oh,
putting
lot.
his hands on her, you just saw like he's kind of doing that, like
he was
shoving,
nudging
pushing
her.
her.
But then when they got in the car, you heard her scream, and then like they drove away fast after that. And that's when I went inside to go tell my manager. If like a cop comes and talking to me, like y'all know that's not me.
Yeah. Yeah, that's
so like that
total.
shit was he got like cruel to her.
What's phone number for you?
615-587-4055.
That was so close. That was so close.
People don't want to like tell me what happened, and I didn't see it myself. I can't
No, but
do
yeah.
too much about it. But yeah, he's going to jail for something else.
No, but yeah, I didn't know what to do because I didn't know like in the heat of the moment it was like I'm right here, they're right there. He was like walking towards me and like kind of like are you listening type thing, and I was like
Yeah.
ignoring him on the phone with my friend. I was like acting like I was talking to my friend. I was like, hey, I'm going home, I'm clocking out type thing.
Yeah, I got you. Well, cool. I appreciate you coming down here and talking to her real quick. You have a good one. Yeah.
AZDC at Oversight Group, 23 months. OG. Thank you very much. Yeah, these people just throwing out numbers. I have to mute in a hurry.
He was threatening to kill her. That was a complaint that just came down here. Said that he was threatening to kill her and kids. Like she was like all shook up. She was like, he was like doing like that nudge and pushing, and they both got in the car together. And she started screaming, and then they drove off real fast. I don't really think that I have enough because she's not going to cooperate. She won't tell me of that.
You know what that is?
It's supposed to be a cap repair. When I first pulled it out, I thought it was a blunt splitter. That's what it felt like. That's what it looked like before the light was on. He's like, that's a kid.
It's a little, a hair net? Tiny little hair net? Northwest, not sure if we're going to cover that one. It depends how things shake up.
Probably because he was yelling over me. Yeah, sorry. I was asking y'all to step it up as I was trying to do because, like, as soon as I walked up there, he was...
If we give out private personalized information, that's a violation of YouTube's terms of service, and I get a video takedown by YouTube.
Yeah.
So
I was trying to ask y'all to step it up, but because I didn't know
zeroes out
Yeah, I didn't know you were still coming hot, but...
any revenue for that video.
Yeah,
and it makes the video disappear.
I expected him to start acting a fool.
That's why we always mute part of every phone number.
I don't think she's gonna cooperate. So. Ask him if he wants his denture stuff or whatever this is. Did you want this going with you? Or you can put it in the car?
You want that stuff?
Your repair kit thing?
We'll take your silence as a no, so yes or no. Oh, so yeah, I was putting a...
Yeah, did you want this to go with you? Give it to her. Do you need anything else out of the car?
No, I want you to let me out.
Cool.
It's a filling for a tooth? I thought she said hairnet.
There's that. He told me to just give it to you. It's like some kind of repair thing, something for
it's
tooth.
for his tooth.
Yeah. Will we do all that? Cool. You haven't read it yet?
I haven't.
Okay,
No,
so, like,
I read it. I literally just finished
yeah,
it.
we went over it. Like, I went over it. I did have an ex-boyfriend that did, like, put his hands on it.
Yeah, I got you. Look, I mean, like...
It's been years ago, but damn, I cut my ear somehow.
Here's this, man.
I cut it at work yesterday. Really stretched.
Oh, okay.
So, it's just
So,
I don't want to get blood on them.
my thing is that I got people telling me a completely different story than what I'm being told by both of you. And that's cool.
I mean, I told you, you can ask them if he threatened to kill me and them, like.
Yeah, it's cool.
And I can't even get back there to him because they got a chicken.
I got you. Well, it's just so concerning
Well, I
about
have a
how
chocolate
aggressive
pie.
he apparently was being with you. So, but if you don't want to cooperate,
I'm gonna be
that's-
real, like,
that's
right now, I
fine.
told him, if he did, it would be a totally different call. It wouldn't be a domestic, it would probably be a murder.
If you did, it would be a murder.
Alright. Well,
I can handle myself.
I got you. Alright.
All right, thank you, Assistant Elbow
For the record,
Spratt.
Your Honor, we just played continuously through to 21:13:59 seconds from the previous start time announced.
All right.
In this video you just seen, you said, stop making this a thing. What do you mean by stop making this a thing?
So you were making the situation into something it didn't need to be.
Would you say resisting, arresting me for a false resisting arrest, be making it a thing?
What are you asking?
Arresting me falsely for resisting arrest, would that be making it a thing?
I didn't falsely arrest you for resisting arrest. Probable cause was found on several occasions, actually.
Keep saying
Would
that.
it be making it a thing to arrest someone and not cite them when statute requires a citation?
A citation's not required for resisting arrest.
So I could have continued the resisting arrest after a citation?
Is that a question?
Yes.
What's the question?
So I would have continued, the incident would have continued if you would have cited me
Cited you for what?
for resisting arrest?
We don't cite people for resisting arrest.
We arrest people for resisting arrest.
You stated to the arrest and the other officers that you called for backup, you had to drag me out of the vehicle. Did you have to drag me out of the vehicle?
That I'd assist you out of the vehicle? Yes, absolutely. You can see where I'm holding pressure on your arm to get you out of the car. And you're holding up on several times and you jerked away from me at the beginning and it wasn't to take your seatbelt off.
So it wasn't to point out a knife on me or anything like that or take the seatbelt off? That's what you're saying?
So I grabbed your arm and you pulled your arm away from me. Then you placed the cigarette in your mouth. Then you decided to take take the seatbelt off. And then you started getting out. You were hesitant. I'm pulling on your arm. And that's when you were like, hold on, I have a knife in my pocket. And I took the knife out of your pocket. And then you got out of the car. We began walking back to the car. I was holding your arm. And you again jerked to put your hands in the air when you were asking if those were male officers that were arriving on scene.
But the resistance came for not getting out the car, correct? The resisting arrest charge came for not getting out of the car, correct?
Resisting arrest from the whole incident of not getting out of the car and me having to assist you out of the car, yes.
Okay.
That's where she gets into a shady territory.
Okay.
There has to be an arrest. You can't resist the arrest you're resisting, right?
Separate me first to address a domestic. Is that your only method of addressing a domestic, or was that your chosen method?
It was the method that I chose that made the most sense. You're the driver of the vehicle. That keeps you from driving the vehicle away with the potential victims in the car. I don't know what's in the car, if there were weapons in the car. I have all of these officer safety concerns due to your behavior and how you're responding to me and how you're acting. So the most reasonable thing would absolutely be to remove you and come talk to you instead of removing everyone else from the car because you didn't want to get out.
How many other people was in the vehicle?
Oh, you had children in the vehicle and she was in there.
Can you give me a count of how many people was in the vehicle?
I do not have a count of the number of people that were in the vehicle.
So you pulled me out the vehicle and you can't even remember how many people was in the vehicle?
Well, she was in the passenger seat, and then there was a huge aquarium in the typical area where someone would be sitting as the passengers, and then the kids were in the very, very back. I'm not sure the number of kids that were in the very, very back.
You sure there was nobody else in the vehicle?
Not that I observed.
So you secured the scene for your safety by pulling me out the vehicle, but didn't search the rest of the vehicle?
Didn't search the rest of the vehicle.
You didn't want to see if there was anybody else back there, maybe some potential weapons in there, weapons of mass destruction, anything in the vehicle?
I separated the parties to investigate what was going on.
Okay. I mean, you were saying for officer safety, you took me out the vehicle, but I'm figuring officer safety is checking to see if there's any other harm in the area.
You're no longer in the car. You no longer have access to those things.
Oh, so I'm the only threat on the scene.
You were removed from the car so I could speak to you. You were the person that I was dealing with.
So as soon as you got to the scene, so it sounds like to me that I'm the person that you were targeting. Is this true?
Vaughn, you're making statements again.
I'm sorry, Your Honor.
You must ask questions and not make statements.
Do we count that as an objection?
Okay. So did you ever check the female on the scene?
Yes, sir.
You did?
Yes, sir.
You patted her down?
Oh, did I search her? You
Yes.
said checked. I thought you were asking if I'd checked her license. I'm sorry.
Oh, yes. Did you pat her down at any time?
I don't believe so.
Okay. You didn't feel the need to?
No, sir.
Okay. Did you check her driver's license?
Yes, sir.
Okay. What about the other witness? Did you check her driver's license?
What other witness?
The witness that pulled up at the back of your vehicle.
Call her.
Judge, at this point, I'm going to object to relevance.
Sustained, that's not relevant.
The relevance being that I was also arrested for driving on revoked, Your Honor. And
how is checking the license of the person who came to the scene relevant to whether or not you were charged with driving on a revoked license?
because it seems like I'm the only person that got checked for anything at this scene, Your Honor.
Right. Well, I am sustaining the objection as to relevance. In this court's opinion, it is not relevant whether or not they checked the driver's license of the person who came to the scene.
Okay.
He wants to tell them how to do their job, and unfortunately,
you said there was
that's not how it
some other people at the scene. Did you say they were victims? I believe. That where threats was made towards them. So I don't know what you call them, but there was other people at the scene, correct? That threats was made towards.
Yes, sir.
Okay. Did you have a question them?
It's my understanding they were children. Typically don't ask questions of children. It's already, traumatizing to a kid that's dealing with police in general. We've had this whole ordeal at the car of you getting out. I did not see it necessary to have this discussion with the children. I spoke to the female who was the other party who was supposed to be being threatened.
Is that procedure, not question children, or that was your own opinion?
It varies on the situation of their age. A lot of things go into play. A lot of times we do not question children.
What would you say their ages are?
I don't know their ages.
You never spoke to them at all, did you?
I didn't speak to the children. I said that.
Okay. So teenagers, do you think they're old enough to be questioned?
Objection.
Judge, I'm again going to object to relevance.
Sustained. It's not relevant. You were not charged with domestic violence, and as a result of that, a lot of this information that you're going to is not relevant to the charge that's being tried. The jury is only considering the retaliation for past action charge, so you might want to focus on that. So.
Yeah, I believe I am, Your Honor. I just don't think I'm asking the questions the right way. It all stems to run together. I'm just trying to prove that I was targeted in a matter that nobody else was, Your Honor.
That's not the issue, though. Part of the problem is the defendant thinks that he has rights that he doesn't have. Part of the problem is the officer behaved unprofessionally and arrested something with an overcharge. It should have at most been impeding investigation, not a resisting arrest.
Okay, in the video, you also said to the witness that came to the scene, you said, that's why this sucks about domestics. People don't tell me what happened, and I can't do nothing about it because I didn't see it. What do you mean by do nothing about it? What do you mean by that?
Well, the witness came to the scene and she obviously was concerned about what she observed. And I was explaining to her that sometimes victims of domestics, if those threats were made, for her to feel that uncomfortable to call police and show up to the scene, sometimes, if that all happened, sometimes the victims of domestic violence are not cooperated. They don't cooperate well whenever law enforcement comes to the scene. So, yes, it sucks for that victim or for that person who may need protection if they aren't cooperative with us for us to help them.
Okay, would you believe that the witness was very credible?
Yes.
Okay, the passenger in my vehicle, would you say she was pregnant?
I don't know if she was pregnant.
Okay.
Judge, I'm going to object again to relevance to this whole line of questions.
What is the relevance, Mr.
Just to challenge her observation of the whole scene, just to show that, once again, she was just only focused on me at the scene. She wasn't really investigating nothing, Your Honor. She had a whole objective of just wanting to charge me because I made her mad, Your Honor.
Well, I am sustaining the objection because whether or not the passenger in your vehicle was pregnant or not pregnant was not relevant to the proceeding to the issue that we're dealing with and the charge we're dealing with. Sustain the objection.
Okay. Was there a witness statement made by the witness?
No.
Okay.
Judge, I'm again going to object to relevance.
It is a fact.
Investigation of the domestic. He is not charged with domestic.
The situation the officer was in.
Has played the video. The
to
jury
that call.
can look at it as they want. There's
The
just no
courts have
relevance.
upheld
to
they
this
have
line
the
of
right
questioning.
to pull them out of the vehicle.
Okay, let's
And
go
they can
back to
say,
the
get out of the vehicle, and they have
video
to.
that
That's a
Mr.
fact.
Danny
And
played
the
for
defendant's
us
wrong
earlier.
about that.
You stated that you was assisting me to place me in a cell. This be acting outside the scope of your duties?
I wasn't assisting to place you in a cell. I assisted the other officer. They were trying to remove handcuffs from you, and only one arm was being secured by the other officer. Your right arm was not secured at all. So if you take those handcuffs off, both hands are free, and now we have an arm that's not secured. I'm not going to put anybody else in a situation to put anybody else in danger.
So, to put someone in danger, would you say you were the one creating the situation?
No, sir.
You have it was a body cam footage we seen, correct?
Yes, sir.
So it wouldn't show your face remarks or your smirking or anything else you're doing, correct?
No, you wouldn't be able to see my face.
Are you familiar with the jail policy for de-escalation?
I don't work for the jail.
Oh, you don't work for the jail, but you assist them at free will?
I never stopped being a law enforcement officer. I'm not going to let them be in a situation where they're placed in danger, removing handcuffs where only one arm is secured. That's unreasonable.
So when you enter into the jail and you place me in their custody, does your custody end there?
Transfers, but it's
You
still
go
law
into their
enforcement.
custody, yes.
So I go into their authority, correct?
You go into
Responsibility.
their custody. You are booked into the jail and you're in their custody.
Okay. So you said you're not familiar with your policy doesn't say anything about your authority ending when you place me into the jailer's custody?
Just statewide authority.
Your policy for de-escalation or enter into a penal facility or nothing? That it doesn't say anything about your authority ending once you place me into their authority?
No.
I'm not sure what you're asking
An
as
officer
far
could
as
respond
that
to a
goes.
call at the jail and arrest people there if they need
Still
to. Seems weird.
feel
but-
obligated to assist if officers being placed in an unsafe situation, yes.
Okay, so let me ask you this. Does your policy state that the only time that you assist in a situation in the jail is with their requests, that you just don't jump into nothing like that?
I don't believe our policy clarifies, but if it did, I would argue that I'm not going to place other officers in unsafe situations.
But with you present at the scene, and you seem to be the problem that how are you placing officers in a situation by just stepping back and stepping away?
You were making the situation a thing by escalating the situation because you would not let them remove the handcuffs. And then they were going to remove handcuffs and we were going to have an arm that wasn't secured. That seems like an officer safety issue to me.
I did not pull away until your hands touched me, correct?
If I recall correctly, you were walking towards me, staring me down when Officer Gonzalez or Deputy Gonzalez grabbed your arm and pulled you back.
I don't believe I was freely, I can't say that. The statement you have in your printout here that you typed, you said, on page 1, it states that right after you told me your name was Lindsay, you said, I just gave you respect, I'm taking it back, is what you said I said. You say I was joking or being serious at that moment?
I felt like at that time we were still on okay terms until we started the following statements that were made.
All right, what about when you said, what about when I stated, no, I'm just letting you know, who I am. It ain't no threat or nothing like that. You said, you kind of just threatened me, but it's cool. What did you mean by that? It's cool.
You can threaten me if you want to threaten me. Like, if that's what you want to say, you can say that. But I'm not saying that it wasn't a threat, because it was still a threat.
So did you take it as a threat, or did you saying it's cool because I ain't taking it as a threat?
The statement is a threat.
How did you take it?
I took it as you were saying, I am a threat for a reason.
But did you take it as a threat? Like, was you in fear?
I think where the separation between a threat being made and an assault is the threat was made, not like an actual action happened. At that point in time, like, yes, kind of concerning that you said that, then with preceding statements added on top of that.
Let me ask you this. Was there a reason to be alarmed at that point?
I was caught off guard while you started talking about being a threat because we had been having normal, reasonable conversation before that.
Do you recall in the video where right before you went off and started to print off your paperwork, that a jailer asked me, said, "You look scared." Do you recall that? Do you think, Well, let me ask you the question. Do you recall that?
The comment about you being scared?
Yeah, a jailer said that I look scared in the video.
No, one of the other deputies were talking in the background to the nurse that was there and said something to the effect of, "You look like you didn't know what you just walked into." She was speaking to the nurse that had just walked up from the jail.
No, she was actually speaking to me, but your paper, well, I can't make that. I'm trying to explain the situation, Your Honor.
What he's getting at is in
uploaded
Tennessee,
video. You couldn't see me respond,
you have to
but
feel
I
threatened
responded to them.
for it to be a threat. The victim has to feel threatened.
Did you take that, you stated, well, you answered that statement. I was going to ask you next, did you think that statement was serious or false?
And it's not necessarily just the victim. A reasonable person in the victim's position has to feel threatened. So I think he's got a valid point here. In cuffs, surrounded by officers, and I said, and I'm saying, oh, I would, work you over, whatever.
I have for you right now would be
under Tennessee law.
Towards the end of the video,
he can't be charged with that, but he wasn't charged with the well.
You're laughing. You live in Dixon.
He was charged with the. Let me check the elements of the specific.
You started
his
laughing.
charge.
Why were you laughing?
I'm not going to say, "Oh no, I'm so scared," because you are implying that you know where I live. I'm not going to show fear in that situation.
Did you actually charge me with retaliation of past act?
It was presented to the grand jury. I did not obtain warrants for that charge, no, sir.
What was it? How many months away was that? Like after the arrest? Would you know?
I'm not positive on the length of time.
Say about 5 months after the arrest.
I don't know the exact amount of time, but if
during that 5 months, did you receive any threats or run-ins with me, or have any issues after that?
as I previously stated, I've only had contact with you during this encounter and in court.
Okay. Do you think it was necessary to put a past act retaliation on me after 5 months and no issues?
I think that it was applicable in the situation. Threats were made to me in the capacity of a law enforcement officer for doing my job.
Okay, so you don't think it was just retaliation for the false arrest?
I think he met the elements of this crime.
There was no false arrest.
Okay, so you felt the charge was necessary to be placed on me?
Absolutely.
Okay. Thank you, Your Honor.
She's right. It was not a false arrest.
Redirect.
The charge may have been excessive, but she had plenty of reason to arrest him. Reasonable, articulable suspicion.
Corporal J. Evans, to be crystal clear, the person that we heard in that video making those statements to you that you identified as threats, was that the defendant, Sharik Vaughn?
Yes, ma'am.
Could you point to him for the record, please?
Yes, ma'am. He's over here. Black shirt, red tie.
Judge, if the record would reflect that she has
The
identified the
record will reflect she has identified the defendant.
A couple of things from the video that the jury has watched. Did you let the defendant smoke a cigarette after he was already under arrest?
He continued smoking the cigarette after we walked back.
So you let him keep it? You didn't take it away from him?
No, ma'am.
And you tried to bring him something in a small container. What was that?
I believe it was some type of something for his tooth. It was some type of, I think he had an issue with his tooth, and it was something for that.
And you, the defendant's attitude from the beginning of the interaction, it goes up and is sort of elevated, agitated. And then we see him calm down. Does he ever get agitated
Objection,
again?
Your Honor, leading.
I don't think she's finished the question. I think she's giving a prefatory statement before she gets to the question part, but let me hear the rest of it and I'll consider your objection.
Does the defendant ever get agitated again like he is in the beginning before the interaction in the jail?
Overrule the objection. The statement she made was prefatory in nature to describe what she was going to ask.
Do we ever see him, or did you ever see him get agitated again other than what we see at the jail?
No, ma'am.
So we see moments of almost joking conversation between you and the defendant and other officers and the defendant.
Yes, ma'am. After the initial coming back, after he was in the car, the demeanor was completely different until we walked into the jail.
Dr. Bob.
We got to the side porch.
Thank you so much. Welcome. OG Boy Mama times 3,
I
member
have
for
nothing further, Judge.
14 months. Thank you for your support.
Thank you, officer. You may step down.
In Tennessee, officers do not need reasonable articulable suspicion to ask for ID or to ask
They
someone
may
to
call your
exit a
next
vehicle.
witness.
Judge, I believe there is a jury out matter before the next witness.
Ladies and gentlemen, if you'll step across the hallway, let me consider whatever this issue is, please.
They can do those requests in consensual encounter or initial investigation. They can do both of those. But that next step, forcibly removing them from the vehicle, usually you need that reasonable articulable suspicion at that point. I don't think the state can prove that she had that at that point.
Awesome.
Honestly, I think there's a chance this defendant can win this case if he can articulate the points of the law well enough, which he's doing better than most do pro se, but I just don't think he's putting it together where the jury can connect the dots. So to his detriment.
All right, what is the issue?
Your Honor, this is for Corporal Stewart, our next witness. Make motion to exclude regarding statements pursuant to Tennessee's rules of evidence of 403 probative value substantially outweighs the prejudice effect. And I was in custody with no ability to carry out the threats. The statements was not made specifically at Jarvin's, who was
does have to be specific.
in the indictment, who was named victim in the indictment, is not relevant to any fact about Jarvin's more or less true. So object to Rule 401 and 402.
Lots of bailiffs here.
You're objecting to the testimony of this of the witness who made the statements that, or repeated at a hearing earlier, that you had said you had a bullet for all of you or something on that order?
Yes, sir. I mean, he also testified that he didn't witness me state anybody's name. He just made an assumption that it was for all in law enforcement. There's no relevance to the statement.
Certain to everyone generally, not
So
someone
are you
specifically.
objecting to relevance, or are you objecting under the rule that exclude, I'm assuming you're looking at other, the rule of evidence having to do with other bad acts?
The Rule 401 and Rule 402, Your Honor.
So it's what, prejudicial?
All right, let me hear from the state.
Judge, I have a good faith belief that the officer's testimony will be that not only did he hear these statements, they were an hour and a half to 2 hours after the arrest and after the after Javins would have left the jail. It shows not only a continuation of the anger directed at Javins and other officers, but that continued anger shows that there may be an actual intent to carry it out, because once Javins was removed from the jail and removed from his presence, he was still making threats to harm law enforcement. And they distinctly go hand in hand with the threats that he had made earlier.
The objection is made under 401 and
Say one more rule, Your Honor, 403. And the intent was never carried out, Your Honor.
That doesn't, I don't think it has to be.
It's not a factor in the naming offense, or the naming charge, Your Honor.
all right. Have a seat. The objections are made under Rule 401, 403, and 404. 401 of the Rules of Evidence is the definition of relevant evidence. 403 is the exclusion of relevant evidence on the grounds of prejudice, confusion, or waste of time. Rule 404 is character evidence not admissible to prove conduct. there are certain exceptions, including other crimes. The court finds that the objection should be overruled because from the pretrial hearings that we had, the testimony of this witness is that he was dealing with the defendant at the jail, and that the defendant made statements that would indicate that he had intent to cause harm or made threats against other law enforcement, including possibly the corporal who testified in this case. My recollection was that he said, "I've got bullets for all of y'all." That, in my opinion, can be construed definitely as a threat, and that threat would factor into the definition of the crime for which he is on trial. So if the crime for which he is on trial constituted by threats, oral threats that are made, then those threats that are made constitute evidence of the crime itself, and therefore they are not evidence of other crimes, but rather are evidence of the crime for which he is standing trial. It is extremely relevant, and therefore the relevance, because it is the very nature of the charge for which he is on trial, the very relevance of those statements that would have been made to go prove beyond a reasonable doubt, if the jury so finds, outweighs any prejudice to the defendant. Clearly, any evidence of guilt can be prejudicial, but in this case, it is the fact that the statements that were made were part of the proof that the state intends to rely upon to prove that the defendant actually made a retaliation for past action threat. That definition that the jury has to find is that the defendant threatened to harm the alleged victim by an unlawful act, that the alleged victim had been a law enforcement, and that the defendant did so in retaliation for anything the law enforcement officer did in official capacity as a law enforcement officer, and that the defendant acted intentionally, knowingly, or recklessly. So clearly, statements made at the jail after the instance that we've seen that indicate
that's
that
the whole
he,
case. The judge
has
just summed
bullets,
up.
if that is the terminology for all y'all. It is extremely relevant, and is, while prejudicial, it is outweighed. The prejudice is outweighed by the relevance, which goes to the very crime for which he is on trial. Therefore, the objection is noted, the record is preserved, and I overrule the objection.
The
now
initial arrest was legal.
You have this corporal. How many other witnesses do you have?
Lieutenant. He's lieutenant. Only Lieutenant Stewart. No. Sergeant. Sergeant Stewart.
All right. My concern is whether or not we're going to be able to finish this trial today. I'm assuming we can move quickly through these next witnesses.
Judge, my proof with this witness should be about 10 minutes.
All right. Well, since the jury's out, let them have this as their afternoon recess, and we will
We're going to skip ahead.
come back. Let's make it about 10 minutes for us. Everybody that needs to take a restroom break, take a restroom break, and we'll come back and resume.
Sounds good. We're going to skip ahead. The judge listed the elements of the charges. I'm going to go over them really quickly. Elements of the offense. This is retaliation for a past act in Tennessee, and it's the Tennessee law that applies here. And it's Tennessee Code annotated section 39-16-510. It has to be an intentional action, meaning the defendant acted intentionally. It can't be like, oh, he passed out and fell down, and I felt threatened by him falling in my direction, right? That would be an unintentional act. This, I think, clearly meets the standard that you can say that this was an intentional act by the defendant. Harm or threat. The defendant harmed or threatened to harm a specific individual. In this case, the victim does not have to feel threatened, but the threat has to be there, and I've got the bullet thing that works, or I'm going to beat that B up. That would qualify, but it has to be specific. That's why the defendant's always talking about. Let me pause for a second, Judge. Wait for a minute. Where he's saying, did I target you directly, or was it just in general? That's why he's going for that. I think there's enough evidence that the jury could at least consider it as a target to a specific individual. It does a specific victim. The victim must fall into certain categories, and it includes a law enforcement officer, which both jail corrections staff are, as well as peace officers on the street. Official capacity, the harm or threat was in retaliation for something the victim did in an official capacity. I think this is going back to her talking to the defendant on the way there, and she said her name was, I forget, Lindsay. And he's like, you lied to me, and that he, because of how you've treated me in this interaction, I don't trust you, and it escalated to and this threat situation. And it has to be an unlawful act that the defendant is using. The defendant used an unlawful act to harm or threaten the victim, and the unlawful act, shooting someone, is in fact unlawful, unless it's the firing squad, and we'll get into that today. So I think there's enough for the jury to consider this under Tennessee law. The officer did have reasonable articulable suspicion, which it's enough in Tennessee, just the caller saying, I witnessed this, for them to make an arrest. That is enough for RAS in Tennessee. Obviously, every state's different. Some states have much higher standards. Some states give people who are stopped by the police a lot more freedoms and rights, I guess, recognize more rights by the individual and restrict the police officers more so. If you don't like the rules in your state, the way to change it is to change the law. Unfortunately, fighting against the law, saying it shouldn't be this way, typically ends up in breaking yourself against the law or breaking the law and paying the punishment. But hopefully that helps a little bit. It's a little bit crazy, but every state's different. And so as we're here in Tennessee now, I just thought I'd give you the laws as they stand in Tennessee, according to my understanding. So let's continue. I do hope that he makes some headway here. I don't condone his behavior. He's obviously he's called out the officers for their inappropriate behavior, which I think is appropriate. I mean, it's appropriate for them to be called out for their inappropriate behavior. I think they should be, as peace officers, as police officers, sworn officers to serve and protect. They should be a little, that we hold them to a higher standard. But I also think that we as citizens should be more respectful in the way we interact with other people. You don't spit in someone's face because you can, type of thing. And I think that some of his attitude carried that with it. All right. Waiting for the jury. Elbow counsel is pantomiming something. I caught a fish this big. I was using a little bait. Like it was like that. And I reeled it in. And you wouldn't believe it. It was like fish on. Yeah. So it was a good weekend. I don't know what he's saying right now, but I think that's what it is. And then I did it again. I reeled another one in. Boom. That's how to do it. I'm just a good fisherman. Put it in my pocket. Yep. That's what I do. I invited him to come fishing, but he was in the jail, so he couldn't come. Hey, next time when you're out of jail, we'll go fishing together. So. Okay, everyone, be more respectful in chat just a little bit. If you've got a disagreement with someone, let's just step back a little bit. I know some of these cases invoke some strong feelings as they either hit close to home for personal experiences or family members or strongly held opinions. Let's not make it personal between each other. We're all friends at the end of the day. And don't make the mods have to time people out. And if you did get timed out, please just take it as a subtle correction and come back in a little bit. It's Friday. The mods have been so good not having to time people out all week. The weekend's almost here. Looks like the jury's come in and have a seat. Let's turn the mic on, Judge.
You may call your next witness.
There we go.
State calls Sergeant Justin Stewart.
Just remember, everyone is innocent unless proven guilty in a court of law. The court has not proven him guilty yet.
Sorry.
So
I do somewhere.
We all should be on the side of the defendant right now.
Raise your right hand. Let's place you
until
under
we're
oath. You
convinced
solemnly
otherwise by
swear
the
affirm the
evidence.
testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God. All right, thank you. Have a seat. Speak directly into that microphone, please.
Are you Sergeant Justin Stewart with Dixon Police Department?
Yes, ma'am.
Would you spell your first and last name for our court reporter?
Yes, ma'am. First name Justin. Last name Steward, D as in David.
On June 18th, 2022, were you working in your capacity as law enforcement?
Yes, ma'am.
And you were actually out on scene assisting Javens at the original call.
Yes, ma'am.
And that was the first time that night that you saw the defendant.
Yes, ma'am.
Did you see him again that night?
Yes, ma'am.
Could you explain to the jury where you saw him and what got your attention?
Yes, ma'am. So, am I allowed to talk on the video that's been played? So, like, or did they see the whole thing? Or?
So, let me walk
What
you through a
video's
little
been
bit more.
played? Hang
So
on.
Okay.
they're aware of what the call was about, but you, and let me just
He
help
knows
you
what
to the
video's
point
been
that we're
played?
at. Did you go back to the jail later that night?
Yes.
Did you going back to the jail have anything to do with the defendant?
No, ma'am. In fact, what I was going to mention is that whenever she called for units to step it up, I was en route to another call for a warrant service. So once her call concluded, I then went to the call that I had told her about, and we made an arrest, and that's how I had contact with them again. So
The warrant service means someone has an outstanding warrant and you're going to serve it. Okay, so you serve that warrant, you take that person to the jail. What happens next?
So, at the time, I believe I was still a corporal then. I had recruit Floyd with me. So whenever we have recruits that are in training with us, we kind of slow down some of the paperwork as far as, you know, where originals go, where copies go, things like that, standard training things. So once we concluded business with the subject that I arrested, who was cooperative, we served as warrant advisors, court date, et cetera. We made copies of all paperwork. And then jail staff kind of took him away. Our business was concluded. So unfortunately, at that point, that's where we turn off our body cameras, right? And Mr. Vaughn was out in the, I guess you could call it the common area on the male side and booking, and was still upset and made a comment that he had bullets for all of us or something to that effect. And I simply mentioned to Corporal, I believe at the time, Javens, when we got back to the police department, she just needed to notate that in her report, just in case in the future, you know, she were at Walmart or wherever, and he were to actually try to follow through with those threats. So.
When
I believe the
someone
rule
makes
has
a
been
threat like
invoked on
that,
this
is
one.
it common for law enforcement to note it in your paperwork?
It should be.
And you said in case she sees him out in public. What do you mean?
I mean, if you know, she's out with her family at Walmart or the movies or anything, and he actually intended to follow through on them and cause like harm to her, and she had to defend herself, we would have documentation that she wasn't just out looking for a conflict, you know, that threats were made, and that's obviously something we take seriously, and I believe would put any of us on edge. So.
Did his remarks put you on edge?
Of course, yeah, it's always uncomfortable. That if not, I wouldn't have made it a point to go back and mention it to her that this is worth documenting. It's concerning. You're threatening, you know, officers, and
to the best of your recollection, what were his words?
I believe that it was I have bullets for all of you, or I have enough bullets for all of you. That's essentially what it was. So.
Nothing further, Judge. Well, actually, I'm sorry. About how much time would have elapsed between the end of Javens's call and when you were there?
When I returned to the jail?
Yes, when you returned and you heard these statements from the defendant.
So I can guesstimate, or if I'm allowed to use my phone, I can get the exact time.
A guesstimate is fine.
maybe hour and a half, if I had to guess, ballpark.
So at least an hour, no more than 3 hours.
That sounds reasonable.
Thank you. Nothing further.
Mr. Vaughn, do you have questions for this witness?
Yes, sir. One moment, please.
Well, elbow counsel is writing out the questions for him. I have to say, Mr. Vaughn is getting his money's worth out of this free state-appointed elbow counsel. Mr. Vaughn does have some skill in this area, and he has some knowledge of the law. And we knew he had that before he was even arrested, because he knew that he had rights, that he could reserve rights during the traffic stop. And so he's already had tendencies this way. But with a little elbow counsel, it's really helping him out a ton.
Doing good. How are you?
Corporal Stewart.
Yes, sir.
Oh, Sergeant Stewart now.
That's all right.
Oh, congratulations.
When you entered that jail that night, did you have your body cam on?
I would have whenever we entered with the other party that I had after the fact, if that's what you're asking about, the arrest warrant that I referenced.
Did you manually turn off your body cam?
Yes, once business is concluded with the person that we're interacting with, that's standard, yes.
Which is why the other one went so long, because it wasn't concluded yet.
And you testified previously that Corporal Javins was not specifically mentioned in these statements, correct?
That's correct.
Okay. And you were also on scene when I was arrested, correct?
Yes.
But you're not named as a victim here today, are you?
Yes.
Was a statement.
I believe that'll be all, Your Honor.
I do want to see his closing argument, because I think he's got some points that could put
Any
some
redirect?
reasonable doubt in the mind of the jury.
No, Judge, may he be released?
Thank you, Sergeant. You step down and you are released. You can go about your business, or you may have a seat in the courtroom. All right, next witness.
That's the state's proof, Judge.
State
has rested their proof, Mr. Vaughn. You need to consult with Mr. Spratt before we proceed.
JOA?
Yes, 1 second, please, Your Honor.
Should make a judgment of acquittal motion here. I don't think it will carry. I think there has been some evidence put toward each one of these elements of the offense that's enough for the jury to consider. Mr. Vaughn, to his credit, is displaying...
Your Honor, I believe we're going to need the jury out to take up some matters.
All right, ladies and gentlemen, I need to take up a matter quickly. If you'll step right across the way, hopefully this will not take long.
I think the judge might be flirting with the line of showing that he's displeased with the defense for the amount of time this has taken. The jury should not have any indication from the judge's actions if he has a preference on one side or the other. Hopefully this will not take long.
Right.
No, it's in their interest to not waste time, but let's see, he should give sufficient time to argue this for sure.
Mr. Vaughn, you have a matter you want to take up?
Yes, 1 second, Your Honor. I'm coming.
He has the opening statement as well. You're right, Stacy. He reserved. I think he waived, but I think he meant reserved, which hopefully he's allowed to do.
Did you make any changes?
So he gets to give an open and a closing. JOA is not made in the presence of the jury. That they're out for this one. So
I didn't count them. So.
Elbow counsel is volunteering here. He's not going to be present for some other matters that Mr. Vaughn has in court later on. But he is here for this.
Let's take it up.
Per Rule 29 of Criminal Procedures, a motion for a judgment of acquittal.
There's JLA.
Taking the facts into light, most favorable to the state. No reasonable jury can conclude that I am guilty beyond a reasonable doubt of this charge. Your Honor, no statements were made directly to anybody. There's no harm that was done to anybody.
That's not an element.
To add insult to incident, 5 months delay. There was no carry out of these allegations of the statements I made. The intent was never there.
It's intentional action, not intent to carry out. So far, he's hit one point that matters. That's
and I believe with all the evidence that I showed to the jury, they would be acquitted, Your Honor.
All right, thank you. You wish to respond, General?
Not the most artful one, but he's still incorporating some of the arguments that don't have merit.
And in a light most favorable to the non-moving party, the jury has heard multiple statements that he was going to break a female's jaw, that he was going to beat a female up. All of these taken in relation and in the context of the situation means that they were directed at Officer Javins.
That's specific.
And the jury could easily conclude that they are in retaliation for his arrest, which was done in her official capacity.
Motion for judgment of acquittal is a procedural issue where the defendant challenges the sufficiency of the evidence. And as Mr. Vaughn himself pointed out, I have to review the evidence in the light most favorable to the state, the non-moving party, and as a result of that, I find that there is ample evidence for the jury to find that the defendant has, in fact, committed the crime of retaliation for past action. All of the statements that have been alluded to and been introduced by the state could be interpreted. I think it's an argument that as far as the no harm, statute doesn't require harm. It requires a threat to be made against someone in law enforcement as retaliation for past action. And the argument can be made that, well, there was no present ability to carry it out and so forth, but the statute doesn't require that. So I find that there is sufficient evidence to overrule the motion. And now we move to the question of whether or not the defendant is going to put on any proof.
I think if we have a Momon hearing ready, I think he may call a witness, but I think he's going to make the decision not to.
I would rather talk with him and find out quickly whether or not his intentions are to testify. He should know by now, I would think.
He's not going to, Your Honor.
He's not going to, then bring him around. Let's go ahead and do the Momon hearing.
Okay, quick colloquy with the defendant regarding his right not to testify.
Mr. Vaughn, I'm going to ask you to be placed under oath for the limited purpose of us conducting this, what's called a Momon hearing, and that is where I question you about your intentions to
remain silent or testify.
I'm going to go over it with you, and then if you'll raise your right hand, let the clerk place you under oath.
It is limited. You can't ask him anything outside of this scope.
Fine.
All right, Mr. Vaughn, you are
So this is not waiving his right to
understand,
remain
and I want to make sure you do understand that you have a right to testify in this trial on your own behalf. And if you want to testify, no one can stop you from testifying. Do you understand that?
Yes, sir.
You also understand that you don't have to testify. No one can make you testify against your will. And if you don't choose to testify, the jury cannot draw any inferences from the fact that you did not testify. And in fact, the burden remains on the state to prove your guilt beyond a reasonable doubt as they've been instructed, regardless of whether you put on any proof or call any witnesses or testify. Do you understand all that?
I understand.
Have you talked this over with your advisory counsel, Mr. Spratt, and discussed with him the advantages and disadvantages of whether or not you want to testify?
Yes, sir, I have.
And do you believe it's in your best interest to testify or not to testify?
I believe it's in my best interest not to testify.
All right. Then upon your decision not to testify, I'm going to ask you to sign this form. Mr. Spratt, I realize that you are advisory counsel, but I'm going to ask you to sign as advisory. All right, thank you.
A non-moving party. There are two parties in a case, the defense and the prosecution in a criminal case. The defense made the motion. They are the moving party. that made the motion. The non-moving party is the party on the other side that would object or make an argument against the motion. So in that law about the judgment of acquittal, the non-moving party is almost always, I think it's always, the prosecution. Because the prosecution wouldn't make a motion to say, judge, set this aside.
Right.
Judgment of acquittal, find him not guilty. They could just drop the charges.
All right, then have a seat, Mr. Vaughn. We're ready to, are you going to call any witnesses?
Yes. Something's way wrong.
Then we're ready for the jury.
That happens. I thought he was going to call a witness. Wasn't there a witness at a preceding hearing that they made go out because she might be a witness in this case? I thought that was the rule being invoked, which worries me because the officer who just testified walked in and said, the video that's just been shown, or the video that's been shown, can I talk about that? He shouldn't know there's a video shown. He shouldn't know about anything that happened in court. I'm not sure if the defense is going to raise that issue. But prosecutor's JOA is a motion to drop the charges. Yeah.
All right, ladies and gentlemen.
You can't keep it open if you're not going to have a witness.
Proof. Mr. Vaughn, do you have a witness that you wish to call? All right, call your witness.
I'll call Jennifer Dozier.
He did, in fact, waive his open. So we've had no opening statement. I'm not sure why. There she is. We saw her earlier.
Come around, please, ma'am, and raise your right hand and let the clerk place you under oath.
She may be the other person in the vehicle and the body cam.
solemnly swear.
Mr. Vaughn, you may question your witness.
One second, Your Honor.
She did have a tough time speaking at a previous hearing. Hopefully her voice is a lot better.
Could you state your name for the record, please?
Jennifer Nicole Dozier.
It's better.
How do you know me?
20 years and 3 kids.
Okay,
Pull that microphone towards you a little
20
bit.
years
There
and
you
3
go.
kids.
And we have 3 kids together.
Are you familiar with this case here today?
Yes.
Here comes an objection. He's going to ask her opinion.
The initial call that the police were called for, are you familiar with that?
So we were arguing?
Yes. What did they say it was when I got to the scene?
We were arguing in Walmart.
Okay. Are you familiar with the statements that were made, the reason they came?
I don't remember. It's been years.
Well, the statements that were made were statements that I could cause harm to someone in the vehicles or to yourself. Do you believe that it was possible that I could cause harm to you?
No, not in that moment. We were arguing over a birthday cake.
Do you think I'm someone that should people be scared of?
No.
Would you think I'd be the type of person to
Character evidence.
retaliate on somebody or dwell on things?
Not to my knowledge.
No
Not that I've seen you do in 20 years, but
one of the charges that I was arrested for was resisting arrest. I don't think that's a good question, but I'm gonna ask it. Do you believe I should have been charged with resisting arrest?
well, no, but the charge was dropped, correct?
Yes, it was.
So,
Do you believe I should have been charged with that? Do you feel like I resisted in any way?
The judge is looking at the prosecutor like, you can object?
From your own knowledge, there was other people in the car, correct?
children?
are they well capable of speaking English and understanding English?
Yes.
Do you think that if they were in fear that they would have spoken up if asked?
Yes.
You being their mother, do you believe my kids are in fear of me?
I mean, you're their father. They're supposed to be in fear of you at times, but.
Okay.
Wrong
Do you
answer.
think that they would think I would harm them?
No.
Do you believe that the arresting female officer on the scene, do you believe that she addressed the issues to the best of her authority, you think?
I think she did.
You think she did?
I think maybe she could have called a male officer, but they could have been shorthanded that night. We don't know what was going on.
Okay.
This is weird. I'm not sure why the
I
state's
think that would
allowing
be
it.
all, Your Honor.
All right.
Okay.
Do you have any questions?
Judge, I'm going to need a jury out before we have questions.
Ladies and gentlemen, if you'll step out across the way, I will need to take up a matter in your absence.
Jury out again. What's her shirt say? Does it say y'all? Or it looks like the KISS logo. The tongue. Maybe it's a cross between Miley Cyrus and KISS. I don't know what it is. Southern version.
General, you may ask, or you may make your argument.
It's Rolling Stones.
Judge, I am giving the court notice that I am about to go into prior bad act evidence by the defendant asking this witness if he is capable of harm. He has opened the door to prior bad acts, including that he has previously been convicted of aggravated assault, aggravated robbery, a second aggravated assault, and a second aggravated robbery, if this witness knows that.
She's nodding. You opened the door.
Yes, I am aware of that.
Oh, don't.
I don't feel like
You just need to be quiet. I'm taking that the lawyers are making a motion, so I'll have to be the one to deal with that.
It was a
Door
trap.
has been opened, not just open, but flung wide open and scotched open, it seems to me, by Mr. Vaughn when he asked the question about whether or not
I'm capable of it.
he would be the kind of person who would commit that type of an offense. So.
There you go. Bring the jury. What's the defense argument? Judge can listen to an argument why this wouldn't be. The door has been flung wide open. Oh.
Is advisory council.
Advisory council can make an argument? The judge said that wasn't going to be allowed.
I think it was State versus Wood. Voting about that. Advisory council can be standby council. This could be a situation where
The rule, the court rule is he elected to represent himself. And with that, as I asked him, if he had familiarized himself with the rules of evidence and so forth, then it becomes imperative on his behalf to make sure he's familiar with. And of course, he's quoted in the pleadings he filed that we had motions on, numerous cases, a lot of case law, a lot of rules. He's cited rules today. There's a line at which he's responsible for whatever he chooses to do. And he was advised he would be held to the same standard as a lawyer. Clearly, a lawyer who asked the questions that he asked about his client opened the door to the question of whether or not. Right now, the jury has heard this witness say, oh, no, she doesn't think he's the kind of person who could do that kind of threat. That's a very material issue in the case having to do with a threat of retaliation for past action. The very gravamen of which is that he is capable of making that argument.
Maybe
So
Scotch
the state
Open is like
has
double
the right
Dutch
to
Open.
now produce evidence to show that
counter
this
that.
defendant, through this witness, is capable of such actions if he has in fact been been convicted of other crimes. My intention is to allow this evidence to come in and to give the jury a limiting instruction. Their instruction will be that they are to consider this evidence only as it goes to the credibility of this witness's testimony regarding her belief that he is not capable of such. He does not pose a threat and is not capable of that type of action.
Which impeaches this witness and basically all her testimony that she offered. And it also prejudices the jury.
No, we're moving forward. The reason is, it's not going to make any difference whether you have 5 minutes. You can sit there and have 5 minutes with him, but the fact of the matter is that we're moving forward with the questioning of this witness, and Mr. Vaughn you can consult with him, but it's not going to change my ruling.
And you're gonna have to tell a lot more fish stories. We can't hear you, sir.
All right, General Bryson, question the witness as to what the question. Ask the questions you're going to ask
Doing a proffer
in
now.
front of this, in front of the jury of this witness.
Judge, while this will not be the full cross-examination, the pertinent questions will be, Ms. Dozier, are you familiar that the defendant was convicted of aggravated assault in November of 2016?
Yes.
Are you familiar that he was...
Objection, Your Honor.
You can't.
Objection's knowledge.
We're having a hearing, Mr. Vaughn, and for me to determine, the jury's not here. We're having a hearing for me to determine whether or not this evidence should or should not come in. So you just sit quietly. I'll give you a chance to question, to make your argument, or through your counsel. I'll let you make the argument. Go ahead.
Are you aware that he was also convicted of 2 counts of aggravated robbery in 2016?
I am.
Are you aware that he was convicted of aggravated assault in 2011?
I am.
Those are the questions, Your Honor.
Mr. Vaughn.
So you're asking her about convictions of the defendant for aggravated assault, aggravated robbery?
Yes, Judge, he has 2 convictions for each that are listed on his range notice and impeachment notice.
All right. Then your argument is on the admission of this evidence is what?
Judge, under Rule 404A, the character of the accused on a pertinent character trait offered by the accused may be rebutted by the prosecution.
Solid legal grounds for this.
Judge, the defense having put forward that he is not capable of harm, these are crimes of violence which would directly rebut the evidence that he's put at issue.
Right. Mr. Vaughn, you wish to address that?
Yeah. He could have avoided this. He was doing fairly well. He could have avoided this with a lawyer. A lawyer would know not to ask that question of this witness. And the state, I was saying object. She knew that this was something he was going to go into, or could anticipate that, and allowed it to stray far beyond the question, what the question should be of this witness, and it opened the door.
Your Honor, the questions that I were asking were pertaining to retaliation. And to the best of my knowledge, I believe she doesn't know nothing about the convictions of the defendants. I can ask her yourself for the record, Your Honor, if you want me to.
She just testified that she did. That's the problem.
Ms. Dozier,
No, we're not asking her any more questions. Okay. Now we're talking about the fact of whether or not this evidence should or should not be admitted. I'm giving you a chance to tell me why it shouldn't be admitted.
Because the questions I was asking was pertaining to harm to the children and pertaining to retaliation of past acts. She doesn't have any knowledge of my convictions.
You ask her the question.
So
you ask her the question.
I'm asking her questions from the time that me and her was together at these charges, Your Honor. She doesn't have no true knowledge of them charges. Me and her wasn't even together when them charges happened.
So you're
Your Honor.
impeaching your own witness?
That may be, but she just testified on direct with General Bryson that she was aware of all of those convictions.
She's nodding. Yep.
She wasn't given a copy of none of that. Yeah, I don't believe it should be used, Your Honor.
All right, thank you. Court is going to allow the state to ask the questions, and I will simply limit your question to, is she aware of the fact that he's been convicted of aggravated assault and aggravated robbery in the past, without going into the multiple counts of aggravated assault? I don't think there's any reason for doing that. I think you can establish what you're trying to establish by simply referring to his prior conviction, if she's aware of the fact that he has a prior conviction for that. I still intend to instruct the jury that I'm allowing this information over the objection of the defense for the sole purpose of testing the credibility of this witness and her testimony as to, in response to the questions the defendant himself had asked about whether or not she thought he was capable of these things. Bring the jury in.
The judge throws defense a lifeline, limits the scope to reduce the prejudicial effects of these questions, but the questions are allowed under the law because of the prior testimony, which was inappropriate. That leaves the juror with the jury with an unfair image of the defendant that's inconsistent with the facts as known by the law, by the court. He does have 3 additional cases, which he's told he's not going to get elbow counsel for. He can hire somebody if he wants, but he thinks he's told us.
Ladies
already.
and gentlemen, outside of your presence, I consider it an objection that was made to some testimony that was going to be offered. The state is about to ask some questions of this witness. I am allowing the state to ask questions that, because of the fact that the defendant asked this witness questions about her belief as to whether or not he was capable. You'll remember what the questions were, whether or not he was the kind of person that would have posed a threat and so forth. So the state is now seeking to rebut that testimony by offering questions of this witness regarding some other matters. I'm allowing it to be introduced solely for the purpose of testing the credibility of this witness on the issue on her testimony in response to the defendant's question. You should not consider the evidence you're about to hear on the issue of guilt or innocence per se, but only on the issue of the credibility of her testimony about whether or not he poses a threat or he posed a threat and so forth. So the state may now cross-examine the witness.
Ms. Dozier, you testified that you and the defendant have been together for 20 years?
On and off.
On and off. And you have 3 children together.
I do.
What are their ages?
17, 15, and 12.
And you testified that the defendant was not capable of harm. Just yes or no?
I did.
Okay. And you are aware that the defendant has previously been convicted of both aggravated assault.
Objection, Your Honor. Basis of knowledge, ask the witness to lay a foundation. Basis of knowledge, Your Honor.
Overruled.
You are aware that the defendant has been previously convicted of both aggravated assault and aggravated robbery.
I was where he's arrested on him. I didn't attend his court proceedings, but I knew he went to jail, of course, or prison.
That's
nothing further, Judge.
Redirect of this witness.
Didn't attend his court proceedings. I knew he went to jail and prison. Yeah, that means conviction. Prison means conviction.
To the best of your knowledge, have I ever retaliated to anybody in these charges?
Not to my knowledge, no.
To the best of your knowledge, was any of them hurting any kids?
No.
Okay, thank you.
Thank you, ma'am. You may step down. You may have a seat in the courtroom or you may leave. Mr. Vaughn, you may call your next witness.
Defense rests.
Defense rests, Your Honor.
All right. State have any rebuttal proof?
No, Judge.
All right, ladies and gentlemen, you've heard all of the evidence that
We're going to fast forward through some
to be
of the
able to decide
instructions.
this case. The next step is for the lawyers or the state and Mr. Vaughn to make their closing argument. I would remind you that the closing arguments, both of the state and of Mr. Vaughn, are not evidence. They are not testimonial. They are not evidence. They are simply their argument to you about what they think the case has proven. So therefore, we'll let the state go first, and they have the right to go first, and also to close after the defense.
The bailiffs who run a moving company on the weekends have rearranged the furniture, ready for closing arguments.
Ladies and gentlemen, put before you today is to decide a very narrow set of facts, whether or not the defendant on June the 18th in 2022 knowingly threatened to harm Officer Lindsay Javins by any unlawful act in retaliation for anything Officer Lindsay Javins did in an official capacity. On that night, Officer Javins arrested the defendant and took him to the jail. When they got to the jail, and you were able to listen to the video, and you have the transcript from Officer Javins, it's up to you to decide what you think was said on that video. The transcript is an aid to help you. But the state would submit the following statements demonstrate very clearly that the defendant knowingly threatened Officer Javins for her arrest of him that night. I am a threat. I am a threat for a reason. Officer Javins will say, you kind of just threatened me, but it's cool. And the defendant says, you can take it anyhow you want to. I don't care about none of that. When they begin to take the cuffs off him, notice what he said. Don't take them off right now. Don't do it. He says, Lindsay, if that's your real name, you done lied to me. I done told you I don't trust women for a reason. Stop talking to me. As they begin to get the cuffs off of him, he says, when her jaw gets broke, it's your fault. Okay? He then screams, lion ass hoe. Okay, he's accused only one person of lying. That is the officer. That tells you who he is directing this tirade at. It's directed at her because he's decided that she's lied to him. He then says, and ladies and gentlemen, I'm going to use his words because those are his words that you saw in the video.
Content warning.
The female says to him after he says lion ass hoe, the other female in the room says, hey, we are trying to get the cuffs off of you so you can stop tensing up, please. And Vaughn responds, fuck no, because I'm going to beat that bitch up. Bet on that. As he's going into the cell, he turns to this officer and tells you about something she already told you in their earlier conversation. He says, you laughing? You live in Dixon, Fairview, you talk too much. And then he continues on once he's placed in the cell. Ain't none of y'all safe without a goddamn badge. And then an hour and a half, 2 hours later, he is still speaking in the vein of these threats he's already made, as he says, where Corporal Stewart hears it, he's got enough bullets for all of you. Law enforcement should be able to do their job based on the facts and law in front of them and with no fear of retaliation for what they've done. That is why threats are enough. The officers told you they documented these because these statements might become relevant later on. That tells you the mental effect that these threats had on law enforcement. That tells you that they perceived them as serious, that they perceived the defendant could act on them. And under the law, it is the threat alone that is enough for punishment. Is everyone here very thankful that these threats were not acted on during that time span? Yes. But this isn't an assault charge. He doesn't have to have hit her in that moment. This is a charge for retaliation for past action, and it goes to the threat that were a direct response to her action as law enforcement.
Mr. Vaughn?
She never makes the call to find him guilty. She says, find him guilty. Most people end that way. Okay.
With all the evidence that is shown here today, can we say that we're happy about what happened? No. Can we say that we believe that we should be charged with something like that? No. If the charge should be, I should be charged with something like that, I believe it should be immediate. I made bond probably 12 hours afterwards on the street, went and opened up a business. Actually had a first responders meal for $8 out on a food truck. I build houses too in the community.
Judge, I'm sorry, the defendant has opted not to testify and is
Well,
stuck.
no. You can make an argument about what the testimony has been in this case and the interpretation of that testimony, but you cannot testify, which is what you're doing now. I sustain the objection. Jury will disregard.
Okay. Be honest, like, who hasn't cussed a police officer out before? You get pulled over for a ticket, whatever. I don't care what it is. They get on your nerves just like they get on my nerves. I'm an American. Did I do something? No. Did I speak in right? That's debatable. It wasn't even direct. Throwing stuff out in the air. Should you be? Everybody in here probably said something. Every one of y'all should be charged with it, if you ask me. With the evidence provided you, I've also shown that if it wasn't for the fact I was even arrested in the first place for a charge that they chose to dismiss, a charge that y'all didn't even hear today, this charge wouldn't have been put on me in the first place.
That's his main complaint right there.
I've also took the charge of driving on revoke, which I had very good arguments for that. Documents I could have put in today, but just to show y'all that I was being honest about the situation.
Here comes another objection.
Just to gain some value with y'all, to be honest with you. Just shorten this time with y'all being here so y'all can get back to y'all families.
Pled guilty to that one.
So looking at all the facts that were stated, the officer, there was no fear. This was just retaliation because she couldn't get me for nothing else. It's just simple as that. She's laughing, antagonizing.
This might work.
Really, you ask me, just going outside of her way, if you ask me personally. I'm hoping y'all see it in the same light I was seeing it in. You've heard the statement from my children's mother. She was present. The children were present. None of them feel any harm. They wanted to go home with me. You heard that in the video. I think this was blown way out of proportion. If I was a threat, I had plenty of time to do it. If it was that big of a deal, besides taking a note of it, why wasn't I arrested and charged with it then? Bottom line. It shouldn't be something to be dragged out. If you want justice, do justice then. It's simple as that. I believe I got, that's all I got for y'all. Thank y'all.
Colonel Bryson, do you have any final say?
No. Yes.
No, Judge, I'll stand
No.
on my argument.
No, she stands on her argument. Waves rebuttal.
Let me have one of you pass this out to the jury.
Okay, we're going to fast forward some of the jury instructions. We've already heard the judge explain the charges, the elements of the charge. So he's going to read those to the jury. Right here. The jury goes out. Yeah, they go out at 5 o'clock. at 5. Is this right? 5, 7, 8, 9, 509. We have motion. Let's see what happens here. I think they're leaving. Oh, it's done. What happened? Where's our conviction? Where's our verdict? Did I miss it? I think I jumped on the. Let's see. Judge Wolf. Go back. I think I just missed it. There's 14 minutes of deliberation. Just hang on. We're going to get it. I've got to go back to where it was. It just skipped. Let's see. It jumped to the end. Did I miss it? Help me, guys. Did they not publish the verdict? It's got to be right here. This has got to be it. Everyone's waiting expectantly. It's on the stream. You can't see? Sorry.
We have everybody back. Let me get my court reporter in place, please.
I object.
All right. Ladies and gentlemen, I'm advised that you have reached a verdict. Is that correct? With the
Here we go. All right, 15 minutes of deliberation is all the jury needs to make a decision in this case. Mr. Vaughn is charged with making a threat in retaliation for a prior act to a law enforcement official. The law in Tennessee makes this very easy one to prosecute because it doesn't have to have the defendant do anything to hurt somebody. Just the threat to a law enforcement official, specifically and unlawful. It has to be an unlawful threat. It's basically a gimme. It's an easy one to prosecute. Mr. Vaughn is very upset because he wouldn't be in this situation if he was not arrested for a charge that the state then dropped and chose not to prosecute. So he's frustrated with this, that he thinks that it was blown out of the water. He did an actually good job as a pro se defendant with elbow counsel, arguing his case and even questioning witnesses. He did a big misstep at the end where he called a witness and got in some character witness evidence that was not appropriate, opened the door wide open to let the jury know there were some prior convictions he had that were of the nature to be concerning, to say, yes, you are in fact capable of carrying out violence against another person. And so elbow counsel doing his darndest to help in this one, even at times standing up and making arguments directly with the judge. I don't think it's going to be enough. We're going to find out right now what the jury decided as they're coming in right now.
Foreman or the forelady, please stand and let me ask this as to the charge in the indictment for the charge of retaliation for past action. How does the jury find the defendant, guilty or not guilty? Right. If this is the unanimous verdict of all of you, would you so signify by raising your hand? All right, let the record reflect that it's been a unanimous finding that the defendant is
Help
guilty
us out, Judge.
Of retaliation for past action.
Guilty.
Ladies and gentlemen, thank you for your
Guilty.
assistance in this regard. This was apparently my only trial that I'll have this term. October the 1st is a different judge, right?
It's the only trial.
Okay. You have a different judge who will be here for the October 1st date. So check that number. I'd like to be able to tell you that you don't have to serve again, but unfortunately we can't guarantee that just serving on one jury will exempt you. Once you're done with this term of court, you are exempt for 2 years, but you're still going to be on the hook, so to speak, until we finish with
this
the term
same jury might
All
be
right,
called
so ladies and gentlemen,
in his
you
other
may
cases.
leave if you'd like to exit through the doorway, and then the bailiffs will show you out. Let's have them exit through this way. And they'll show you how to exit the courthouse. If you'll turn your badge in to the bailiffs as well. Any items that you have in the jury room, please grab those.
Wow. 15 minutes of deliberation. The jury said
Right.
that was
Verdict
easy.
was guilty, so we need to order a pre-sentence report. My suggestion is, General, that we set Mr. Vaughn's case on Monday, the 29th, for us to not only set the pre-sentence report or the sentencing hearing, but also to assign a trial date for his next case that is going to be tried. And I assume that would be one of the 3 cases he has remaining. Do you want to give that some thought, and we'll go from there? Mr. Vaughn, I want you to consider this at this point. As I explained to you, you elected to represent yourself in this case, and I think you've had kind of a taste on what that is like. The next trial, I believe there's much more serious charges of aggravated kidnapping and aggravated assault and so forth.
Get a lawyer.
If I remember correctly. And I want you to consider between now and Monday whether or not you would want to have appointed counsel, actual counsel representing you, or whether you continue to represent yourself. If you continue to represent yourself, then I will not likely, unless there's some showing of a reason to appoint an advisory or elbow counsel for the remaining cases. So we will bring you back on Monday, and we'll set trial dates on those new cases and set a sentencing hearing. We stand adjourned until that time. So.
Wow. Mr. Vaughn, get a lawyer. Get a lawyer. So the other case is what you heard the judge say. It won't be Judge Wolf. Yeah, he's handling it right now, but the rotational cycle the judges go through as to who gets assigned cases, he's off. So starting October 1st, which, next week, he's off that cycle, and it will be another judge that hears it. I don't know if the other judge broadcasts the trials. So we might not be able to follow those going forward. Oh, man. The poor jurors, rinse, wash, repeat. They get reused. they're not done. Every other court we go to, you sit on a jury, even if they, you sit for just a day or an hour, they're like, all right, you're done. For the next 2 years, you can't be called. In Tennessee, you're called to sit as jurors for a trial cycle, which includes multiple weeks and possibly multiple months. And they have to keep calling back and saying, do you need me today? How about today? Do you need me today? And they can sit on multiple trials before they're finally excused for 2 years. So one more reason, Tennessee not making friends and influencing people. That's tough. That's a heavy burden. Found guilty. Yes, found guilty. Although the juror was not mic'd. The jury was not mic'd. Yeah, we're done with this case. Let's see. Judge Wolf will be back for his other trials and is presiding over them. I thought he just barely said he wouldn't because there's a different judge. I'm 28 months into my 36-month RA trial cycle. Let's see. I think that's county specific. I'd have to do that when I lived in Nashville. Didn't have to. Maybe they struggle to find juries. We heard that in Florida, that even in the case that we just watched in Florida, there were people who failed to show up that are currently being prosecuted for a failure to respond to a jury summons. That's an issue they have down there. That's only for the month of October. The other trials are after when the Judge Wolf is back. Okay, thank you, Jackie, for that clarification. Then maybe we will get to hear some of those going forward. I hope he gets a lawyer. I really hope he gets a lawyer. All right, it is lunchtime, and as far as I can tell, some of the cases we were hoping would materialize have not. Let me check the... Let's see. Somebody's asking for an email, and I don't know who it is. There we go. All right, you were on time all week. You deserve a Friday afternoon off. Well, I've got a big gig this weekend, and I've done some preparation for it. I still have to do some more with teleprompter prep for 3 presentations and all that. But why in that county of Florida did they decide that the jury should choose sentencing? I've never seen anything like that elsewhere. This is a Florida rule when it comes to the death penalty. A judge cannot decide that you are sentenced to death. It must be decided by a jury of your peers in Florida, and but also only in Florida. It's decided by just 8 of 12 is enough to sentence you to death. It takes 12 to convict you of guilt of the crime, and then in the sentence only 8. It's just one way that every state is a little bit different in the way they carry out their laws, and they're allowed to do that. Just the same as some states have death penalty and some don't. I think it would be a good juror, considering I'm a fantastic trial watcher. Careful, RA. There are lots of text scams happening. No, this is somebody I know about the gig this weekend that need something that I'm preparing, links for live streams. I would love a day off always, Red Pen. I think you've earned one, especially today. It was a rough one today. I appreciate the mods for all the great work they do. Gail Pet member for 31 months. OG. Now lunch for sure. They changed to 8 to 4 because unanimous wasn't happening anymore. Yeah, no one was getting death penalty, and they wanted death penalty. They changed the law. Seems a bit strange, but they did it. Let's see. The best thing you can do is not commit the crime or do it in a state where you like the penalty. I can be a floating sub-mod. Living Ghost, running out to a Bitcoin ATM to pay my fine for missing jury service. Be back later. All right. What happened today that was hard? I missed it. It was a case that brought some strong feelings about law enforcement. Because we saw law enforcement behaving badly. That's enough to upset most of us. I'm not a favor of prison justice. I'm not a favor of law enforcement behaving badly. And we saw some of that today. Let's see. Same in Texas for DP cases. I don't even think the officer realized she was behaving badly. That's an issue. Yeah, and I like that she was called out for it. I don't know if there were internal reprimands. A lot of times those documents are sealed until the officer has to testify in court and they're revealed. It might be that she was reprimanded. It might be that she was, penalized in one way or another. More likely that it wasn't, because if she was, it would have come up in this trial, in discovery. But I don't know. We've seen officers lose their job in Massachusetts. That's for sure. All right, we're going to go to lunch, and I don't have anything for the afternoon. I know there's a case that's going on right now that's on day 3 with, I think it's the name escaped me, Jeffrey Spence trial. We might pick that up on Monday and sort of do a speed watch to catch up. It's day 3. It's still early on in that trial, I believe. I'm not sure how long it's going to go. Don't buy Bitcoin at gas stations, people, for sure. It's the Spirit Box sound case. The sound is terrible, right? The sound is terrible. I've only heard a tiny bit of it, but I've heard that it's very difficult, so I'll have to do a lot of work. Are we coming back after lunch? I don't think we are. I think we're having an early weekend. Here's the thing. Some of the small courts we follow are all doing landlord tenant stuff, and it just makes me cry. It's heartbreaking. You want to fix everything and help people out, and there's not enough dollars in the world to do that. So I don't want to do Judge Cedric Simpson, Judge Middleton, some of those ones we jump to. A lot of the other judges are off on Friday, so there's just not a lot to watch. And it's late enough in the day that we can't watch a full day of court, and it would be difficult. Yeah. The mods need a break as well, a free day. This is for the mods. Everyone, thank the mods by giving them an afternoon off here, and they are absolutely incredible. I appreciate everything they do. What trial is next? Possibly Spence, possibly Stearns if it goes forward. I haven't heard. It was supposed to be starting today. It might this afternoon still. We might do Stearns out of Florida. Stearns is an interesting one because he was caught red-handed. I would expect him to have pled guilty or taken a plea deal. I mean, when officers catch you with the remains in hand of the person you murdered and burned, and are spreading the pieces around, you'd think that that's guilt enough, but we'll see. Possibly an Ohio case. We've got a couple. We will have a new court case for you on Monday. I don't know who to send you to. Is there somebody who's up and active right now that we can portal to? Taking suggestions. Let's see. Not seeing anybody. We'll go to Melody Little. How about that? She's live right now. She's raided us a couple times. We're gonna raid there. If you don't like it, just like it and leave. If you do like it and stay. Tell her thank you. We loved having them come over and raid us earlier today. You guys have a fantastic afternoon tonight. When you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again Monday morning with a new court case. Have a great weekend. Be good to each other. We'll see you on Monday. Bye-bye.